All right, we'll resume the bench trial in Adkins versus the State of Idaho, case CV01-23-14744. We have the same groupings of counsel present, essentially, I believe, today as were yesterday. Mr. Craig and Mr. Grigsby for the state at counsel table. For the plaintiffs, Mr. McKay, Ms. Pletcher, and Mr. Herron, and others seated elsewhere. When we broke yesterday, our witness on the stand, Dr. Corrigan, was her direct examination was, I think, largely but not fully completed. Are we ready to resume with that, counsel?
Yes, Your Honor.
All right, Dr. Corrigan, you may retake the stand. I'll remind you that you remain subject to the oath you took yesterday to tell the truth during your testimony. You may retake the stand. Go ahead, Mr. Herron.
Good morning, Dr. Corrigan.
Good morning.
When we broke at the end of the day yesterday, we were discussing your opinion that the medical exceptions to Idaho's abortion bans are too confusing for physicians to apply in practice and too narrow for adequate patient care. Is that an accurate summary of where we were?
Yes.
Your opinion that the exceptions are too vague, is that based solely on just your own reading of the laws?
No.
What else is it based on?
I have had conversations with upwards of 40 physicians from around the state of multiple specialties. I have also discussed these laws with legal experts from around the state and across the country.
Did your conversations with other Idaho physicians inform your opinion that the exceptions to Idaho's abortion bans are vague?
Yes.
Based on those discussions with other physicians well, before I get there, have you also had discussions with hospital administrators?
Yes.
And did those discussions also inform your opinion?
Yes.
So based on all of those discussions, do physicians in Idaho understand how to apply the medical exceptions in their medical practices?
No.
Objects vague, calls for speculation. She can't testify as to what every physician in Idaho, whether they understand the law. And it's also contradictory to the Idaho Supreme Court's opinion in Planned Parenthood and lack of personal knowledge.
All right. Well, I guess the question as asked called for an opinion as to do physicians in Idaho understand how to apply the medical exceptions? And I suppose it asked for a very categorical opinion that would suggest that Dr. Corrigan is speaking for everyone on that point, and so perhaps the question is too broad in terms of what Dr. Corrigan has the knowledge to testify to, but you can rephrase.
I'll rephrase. Based on all of your discussions with other physicians, hospital administrators, others, are the exceptions to Idaho's abortion bans clear enough for physicians to apply them in their clinical practice?
No.
Objections.
All right. Well, I'll allow that. Witness's answer stands. You may continue.
Out of all of the physicians that you spoke with, how many of them told you that they understood the scope of the exceptions?
Objection, hearsay.
Your Honor, under Rule 703, not only is she entitled as an expert witness, not only is she entitled to rely on hearsay, Otherwise, inadmissible testimony can be admitted if its probative effect in helping the jury evaluate the opinion substantially outweighs their prejudicial effect. Obviously, this is a bench trial, not a jury trial. We don't have any prejudicial effect, and I believe Your Honor can give it the probative value that it's worth.
All right, so what it's offered for is essentially part of the foundation for the opinion, the witness's opinion, that the medical exceptions language in the statute is unclear. Is that right?
Correct.
All right. If you want to further address the objection, you can.
It's clearly hearsay, it's clearly inadmissible because she is testifying as to what other people told her. That's different than just her testifying as the basis for her opinion. The court doesn't need to understand the specifics as what people told her to hear her, to understand her opinion.
All right. Well, I suppose the answer to this, the question is phrased. Out of all the physicians you spoke with, how many of them told you they understood the scope of the exceptions? The answer is going to be?
None.
That's what I assumed the answer would be from the context here, and I think ultimately this is a did somebody tell you a certain thing? And if the answer to that is no, nobody told me that certain thing, I think it's difficult to see that as ultimately being hearsay because it's not getting at what somebody did say, but something that was never said. So I'll allow the answer. You may continue.
Dr. Corrigan, in your opinion, how is the lack of clarity of the exceptions affecting patient care at St. Alphonsus?
I'll object. Again, it's not relevant to the claims that they've brought. They've brought a as-applied challenge, and so the court's decision is limited to those as-applied challenge, whether the case is unconstitutional in those specific circumstances, not general harms, not other people that are not before this court.
Your Honor, may I address that? The plaintiff's constitutional claim asked the court to declare Idaho's abortion bans unconstitutional as applied to essentially patient pregnants with high-risk pregnancies. That is not a narrow as-applied claim related strictly to the plaintiff's own circumstances. In an as-applied challenge like this one, the court is able to fashion relief to the extent that the law is unconstitutional, and that can include appropriate relief beyond these specific plaintiffs, and that support for that is John Doe number 1 versus Reed. And so the testimony about how the abortion bans are harming patients with high-risk pregnancies at St. Alphonsus and across Idaho is directly relevant to plaintiff's constitutional claim.
All right. Well, understood. And it seems to me that the question beyond that is getting at the perceived need for the declaratory relief sought in count 1 as well. I'm going to overrule the objection. You may answer the question. If you need to restate it, the counsel will be glad to do that.
Would you restate, please?
Let's say the question was, in your opinion, how is the lack of clarity of the exceptions affecting patient care at St. Alphonsus?
I have seen several types of direct effects on patient care. I have seen significant delays in patient care due to confusion about whether that patient's diagnosis met the exceptions. I have heard about patients being denied care. I have experienced significant changes and additional stressors in my day-to-day work due to loss of other physicians, obstetrician gynecologists, and maternal fetal medicine specialists. We've had multiple physicians leave the state or retire early, or those who were already planning retirement. We've had significant difficulty recruiting and replacing those essential staff members. And this has required me to work extra shifts, have less control over my schedule. I've also had multiple instances where we simply did not have a maternal fetal medicine specialist available for me to call to consult about complex cases, which is we historically have had MFM specialist available for consultation 24/7, 365, for years. So this was very unusual, and it placed me in a difficult position dealing with a complex case. So there are multiple ways that the lack of clarity has affected my work.
Are you aware of patients who have traveled out of state on their own following a PPROM diagnosis?
Objection, relevance.
Overruled. You can answer.
Yes.
Are there risks to the pregnant patient from driving out of state during PPROM?
Yes.
Can you describe those risks?
So especially given the geography here in Idaho, basically once you leave the Treasure Valley to get to another sizable hospital out of state, it's at least 5 to 7 to 8 hour drive, and the vast majority of those miles are through barren desert without even any services available, without much of it without cell service, without emergency medical services at all. So for patients driving out of state, they face many hours without available medical care, and their condition could rapidly progress. They could develop an infection, become febrile, become septic. They could start bleeding due to a placental abruption. They could deliver the fetus en route. So it is a very scary prospect for someone in an acute medical emergency to undertake such a long drive through areas without medical services.
Are you aware of patients who have had to be transported out of state following a PPROM diagnosis?
Yes.
Can you just briefly describe the process for an out-of-state medical transfer?
So once the treating physician, and by and large in consultation with specialists such as maternal fetal medicine, have made the decision that the patient needs to be transported, we make a call to our transport center. They contact and we identify the institution we wish to send the patient to based on what we know about availability of their services. And so the transport center contacts that institution's transport center. They contact the physicians on call that we hope would accept the patient. They set up a conference call. So all of that process takes up to an hour generally. Then we all get on a conference call. I present the patient's situation, why they need to be transported, why they need services that cannot be provided at our institution. Then hopefully they accept the patient. Then the transport center starts arranging for the physical transport. So generally, these patients are traveling to the University of Utah or the University of Washington. And so the transport occurs by a EMS team arriving at our hospital, placing the patient on a gurney, then taking them in an ambulance to the Boise airport. Then they are loaded onto a small plane. Then they are flown to the airport in Salt Lake City or Seattle. Then another ambulance meets them there at the airport. Then they are loaded onto that ambulance, and then they are transported to the receiving institution. By and large, they travel by themselves. They are not allowed to have any family or support people travel with them. And there can at times be difficulties. I've experienced. They'll call me and say, and I say, I'll call the access center, the transport center, and say, what's the ETA for the patient leaving? And they say, well, we're still trying to find a pilot. So that's often the limiting factor. Also, again, given our geography, we have to deal with snowstorms, wildfires. That can also delay the transport because it's just unsafe for anyone to fly. So in my experience, from the time I make the call to our transport center to the patient arriving at the receiving institution, the fastest I've seen is about 8 hours. But it could take longer, again, depending on those other factors. Also, being the physician who is transferring the patient out, I have to consent the patient to the transport. I have to explain to them the risk of the transport. So as soon as the patient leaves our hospital building and goes into ambulance and airplane, they are automatically in a lower level of care. The ambulances, the medical transport airplanes, they have basic medical equipment, a few basic medications they can administer to the patient. But obviously, they cannot perform surgery. There's no blood bank. They cannot transfuse blood products. They do not have any.
I object to this point narrative, Your Honor.
I'll ask the next question. Are
ahead.
there risks to a pregnant patient who is transferred out of state?
Yes. So their condition could deteriorate en route. And again, the emergency medical personnel that are transporting the patient may not have the appropriate equipment, medications, expertise, resources necessary to best treat the patient, because again, it's not a traveling hospital. They do not have all of the resources available that a hospital does.
Let's briefly discuss some of the relief that you're requesting in this case. Let's say that a pregnant patient steps on a rusty nail. Is that patient technically at risk of death?
Yes.
Can you explain why they technically would be at risk of death?
So the main risk with the rusty nail scenario would be a development of an infection from Clostridium tetani bacteria that is on the nail. And it depends on the patient's vaccination history. so especially patients who have not received any tetanus vaccination or less than 3, or who are not up to date on their vaccinations, would be at significant risk of basically a fulminant infection from that bacteria causing the disease tetanus, which is a significantly life-threatening disease. It's a neuromuscular, the toxins from the Clostridium tetani bacteria are neurotoxins. They cause uncontrollable muscle spasms, which can lead to respiratory failure and death. Especially if the patient also had other pre-existing medical conditions, if they were immunosuppressed due to chemotherapy, due to autoimmune disorders, or due to other conditions such as HIV. They would be more susceptible to the tetanus infection and the complications.
All right. So let's say you have a pregnant patient who steps on a rusty nail but has not developed tetanus, does not have any other symptoms or complications. Do you understand Idaho's abortion laws to allow you to provide an abortion to that patient?
No, I would not think that that patient qualifies for the medical exception.
And are you asking the court to allow you to provide an abortion to that patient?
No.
But are there circumstances in which a patient develops tetanus during pregnancy and does need an abortion?
Yes, so especially if the disease progresses into respiratory failure due to the inability of the chest muscles and the accessory muscles that are needed for spontaneous respiration, and the patient needs to be mechanically ventilated. Patients who have a gestation greater than 20 weeks are known to have more difficulty being mechanically ventilated, and especially if the patient then codes, which is they lose a pulse. It is standard care during that code scenario in which the patient is receiving chest compressions, that the uterus is evacuated ideally within 10 minutes through a hysterotomy, because it has been shown to improve the chances of the patient surviving that code scenario.
We've talked a little bit about lethal fetal diagnoses. What does the term lethal fetal diagnosis mean to you as a physician?
It means that the fetus has been diagnosed with a condition that is known historically to have essentially no significant chance of sustained life after delivery. Some of these fetuses may live for a few hours, days, but need significant medical intervention and do not expect to be discharged from the hospital unless it is in a palliative care or hospice scenario. These fetuses, by and large, also have a very high risk of fetal demise in utero or during birth.
Are you asking the court in this case to allow you to provide an abortion for any fetal condition other than a lethal condition?
No.
All right. I believe your final opinion, you testified, was that Idaho's abortion bans are forcing physicians to depart from accepted principles of medical ethics. Is that correct?
Yes.
Could you tell the court what you mean by that?
So, accepted principles of medical ethics include patient autonomy to make their own healthcare decisions, beneficence, so basically acting in the best interest of the patients, non-maleficence, which is do no harm, and justice, which is equal treatment of all patients. So really all four of those core medical ethical principles are affected. Clearly, autonomy is compromised if there are standard medical treatments that the patient does not have access to and cannot choose to receive in Idaho at this time. Beneficence, again, physicians were not trained to watch a patient's condition deteriorate before they offer standard medical treatments. So that principle is violated. Non-maleficence, do no harm, obviously, delaying care, denying care can result in harm to the patient. And justice, clearly patients in Idaho are not receiving the same care that they would in, for example, Oregon or Washington. So there's not equal treatment of patients.
When you counsel your patients about their treatment options, do you still counsel them about the full range of treatment options, including abortion?
Yes.
What do you tell them about abortion?
I will tell them based on their diagnosis and clinical scenario, if this is a standard treatment, I tell them how that treatment would benefit them, what are the risks of that treatment, and what are the alternatives.
Have you had to tell patients that you cannot provide them the abortion?
Yes.
How have patients reacted when you've told them that you're unable to provide one of the treatment options available to them?
Objection, relevance.
Response?
It's relevant to our constitutional claim, Your Honor. The patients, our claim is about life and safety, ability to secure safety and pursue happiness. It's relevant to that claim.
Understood. Objections overruled. You may answer.
The majority of patients are shocked. Many of them are not even aware of the current abortion laws in Idaho. And those that are aware have a belief that there is an exception for maternal health and for lethal fetal diagnoses. And so when I educate the patients about what the laws say, they are very disappointed and frustrated and scared. And that is probably, those conversations have been the most difficult conversations I have had to have in my entire career.
Have you had very many patients who have been unable to travel out of state to get abortion care?
Yes.
What are some of the reasons that patients have been unable to do so?
Objection calls for hearsay, speculation, lack of personal knowledge.
All right. So the hearsay objection. Talk me.
8034 statement made for medical diagnosis or treatment. Also, present since impression 8031.
So the 8034 notion. So this witness is going to testify to what? These statements were made in the context of seeking medical care, and that they that
Discussion of the treatment options available to the patient, and whether they're able to leave the state, why they're unable to leave the state. It's all in the context of the treatment care and options for that patient.
Greg, you're welcome to respond.
Yes, Your Honor. So at that point, she has already made her diagnosis. She's already made her recommendations. The statements as to whether they can travel out of state or not have nothing to do with the diagnosis or the treatment that Dr. Corrigan is able to provide or not. So it does not fall within 8034. Under 8034B, it has to describe the medical history, past or present symptoms or sensations, or their source. And whether they can travel out of state is not medical history, past or present symptoms or sensations, or their source.
All right. So the argument that Mr. Craig has just made is that 8034 subsection B is not satisfied under the circumstances. Do you have a response to that?
I believe they are satisfied. I will also give you 8031, present sense impression, a statement explaining an event or condition, the condition of being unable to travel out of state.
That's not what 8031 is for, Your Honor.
All right. I'm going to sustain the objections here. Direct you to move on.
Could I add one more thing and try one more time? Traveling out of state is a health risk, as she testified, so whether a patient is able to travel out of state is part of the medical, it's within the realm of the medical condition of the patient.
I agree that 803 subsection 4A is satisfied under the circumstances. I think the issue is B, and I'll continue with the ruling on that basis.
Dr. Corrigan, as a physician with ethical obligations toward your patients, what has it been like for you to practice medicine under these abortion bans?
Objection, relevance.
All right. Well,
Your Honor, one of their arguments is that she lacks standing, and this goes to her own injury.
well, I guess it seems to me that we've discussed that topic quite a bit.
At the
this
very
point.
end, Your Honor, but this is the next. Okay,
All right. What would the next question be?
you testified earlier that you have considered leaving Idaho as a result of the abortion bans, correct?
Yes.
Why haven't you done so?
That has been a very morally trying question for me. If I were to leave, I would certainly, my day-to-day life would be easier. My job would be easier. I wouldn't face these very difficult circumstances, but I believe I would have a significant sense of guilt hanging over me because I would know that the medical care for women in Idaho would have gotten worse than it already is because I left, because I know that there would be no one to replace me in my position. that it would be a significant stressor on my colleagues left behind. And also, you know, if we've already faced a loss of approximately 22% of OBGYNs in this state, and closure of multiple maternity units and hospitals and multiple reproductive health clinics.
This goes way beyond the scope of the question, and she's bringing in a lot of stuff that the court has previously sustained objections, so I'd move to strike her entire answer.
All right, so I think we have covered at this point that the claim, neither claim, as I understand it, encompasses the notion that patients other than in high-risk pregnancy situations or patients carrying fetuses with lethal diagnoses are not going to be able to obtain adequate obstetrical or gynecological care as a result of the statutes. And so I'm going to sustain the objection there, and will strike the answer to the extent it addresses the notion that the OBGYN availability or system of coverage is at risk of failing as a result of the laws at issue. You can continue.
I pass the witness.
All right, understood. Thank you. Cross-examination, Mr. Craig.
Yes, Your Honor, thank you. You are a doctor at St. Alphonsus Hospital, you testified to, correct?
Yes,
You're a hospitalist, is that correct?
obstetric hospitalist.
And so that means you only treat patients at St. Alphonsus Hospital, is that correct?
Correct.
And the only patients you treat are ones who would come into the labor and delivery room or the emergency room and then get transferred, is that correct?
No.
So what patients do you treat?
I also treat patients who are admitted to other services, who have been admitted to the hospital, and my team is consulted for their care.
And you don't treat patients anywhere else other than through St. Alphonsus, is that correct?
Yes.
And how many patients would you treat on a normal shift at the hospital?
Between 10 to 20.
You're not the primary care physician for any patient, is that correct?
Yes.
And you're not the primary OBGYN for any patient, is that correct?
Yes.
You only have a patient when you're actually working a shift at the hospital, is that correct?
Yes.
And on September 11th, you were not working on that day, is that correct? September
Objection.
11th, 2023.
Objection, relevance, Your Honor.
Goes to standing, Your Honor.
Working on the date the complaint was filed.
Standing is determined on the date the complaint was filed. She's testified that she only has patients when she is working.
Question designed to get at, I mean, it was just a day off? Is that where you're going?
So, Your Honor, at her deposition, she testified, we asked, about her patients when the complaint was filed, and she said she had no patients when the complaint was filed. She had no patients on that date. That establishes she lacks standing.
I'm going to sustain that objection. That's not a viable argument. You may continue.
you aware of any doctor who's been prosecuted in Idaho for performing an abortion since the Defense of Life Act went into effect?
No.
Are you aware of any doctor in Idaho who has faced professional discipline for performing an abortion in Idaho since the Defense of Life Act went into effect?
No.
Are you aware of any doctor in any other state with laws similar to Idaho who has been criminally prosecuted for performing an abortion?
Objection, relevance.
She's testified that she's scared to death that she's going to go to prison. I think this goes directly to that.
You can answer.
No, I am not aware of any.
Are you aware of any doctor in any other state who has faced professional discipline for performing an abortion?
Yes.
Since the Dobbs decision has been overturned?
Yes.
Okay, and what state was that?
Indiana.
What were the circumstances of that?
The physician, Caitlin Bernard at Indiana University, faced a hearing with the state medical board over her treatment of a 10-year-old rape victim who had to travel from Ohio to Indiana for abortion care. And because she shared that story, the medical board, I'm not exactly sure what the term is, but they disciplined her and fined her, I believe, $3,000.
That was for a violation of HIPAA, is that correct?
It was because she shared the story, yes.
I want to hand you the exhibit binders. Look at exhibit 1056. Don't read anything in it, but just look at it, familiarize yourself. It should be under tab 56. You recognize this exhibit?
It's vaguely familiar.
So this is a copy of the personnel records that you provided to us in response to our discovery requests. Is that correct?
Yes.
Does this appear to be a true and correct copy of those records that you provided to us in discovery?
Yes.
Your Honor, I ask that exhibit 1056 be admitted.
Objection.
One moment, Your Honor, sorry. Your Honor, at a minimum, this is a very long document, and there are, at a minimum, parts of this that are clearly not relevant, and there's likely hearsay within this document.
So, Your Honor, there's only one page that I think is critical for us. The rest is admitted simply for completion, or we've included all the rest simply for completion if they're not objecting to us just pulling out one part of it, that's fine. But we want to be able to show the foundation for the entire records that this is from her personnel records.
Okay, and then, so what is the part you're focused on?
That would be page 4949.
Okay. And so you're content, I gather, to offer that independently?
Along with the stipulation that this is in fact from her personnel records and all that, yes. I mean, everything else provides the context for this.
Okay.
I guess the 4950 would be part of that same document. So those two pages, 4949, 4950.
Understood. Mr. Herron?
I'm still not sure the relevance of this particular page, so I would still object, but
All right. So I guess I don't know exactly what the relevance is either. I'll permit you well, why don't you explain to me what in particular you contend is relevant?
Sure, Your Honor. She works at a Catholic hospital that does not allow abortions under any circumstances. This is to lay the foundation for the other policies and procedures that she has agreed to abide by. And let me re-speak. They don't allow abortion. I misspoke when I said under any circumstances. There are a few exceptions, but they don't allow abortions.
All right. And so this pages 4949 and 4950 don't contain that policy itself, but you're just you're offering them as just, I guess, evidence, you said, of the.
This shows that she has agreed to abide by those policies voluntarily through her employment with St. Alphonsus. It goes to standing. It goes to her bias. Much of her testimony here today, I think, is completely relevant to all those issues.
All right. If you want to address the subject further, Mr. Herron, you may.
I'll just say, Your Honor, that there's no signature on this. There's nothing on here that says that she has agreed to this. So I'm still don't understand the relevance.
You agree, however, that this was a document that the plaintiffs produced to the defense in discovery.
Yes, Your Honor.
All right. So I think that is enough to establish its authenticity. And so then we're on to is it relevant or not? It's not hearsay. It's not offered for the truth of any matter asserted in the document. It's offered for just as evidence that Dr. Corrigan agreed to abide by certain conditions of employment. I'm not sure the relevance is sharp, but it's a low bar. I'll admit those 2 pages. Those will be, I suppose, what amounts to Exhibit 1056 at this point, reduced to those 2 pages. You may continue.
Thank you, Your Honor. And then this was marked as confidential under the protective order. I would like for her to read those first 2 sentences. I'd ask that the protective order, the confidentiality designation, be removed so she can read those 2 sentences, or those top 2 paragraphs.
All right. Is there any, I guess, confidentiality claim that pertains to these 2 pages?
No, Your Honor.
Okay. That they'll be deemed not to be subject to any confidentiality designation previously made under the protective order. And you're asking her to read the first 2 sentences. Is that what you said?
Yes, Your Honor.
All right. Please do that, Dr. Corrigan.
All colleagues are required annually to complete the attestation below as a condition of their continued employment with Trinity Health. Code of Conduct. I acknowledge that I have received, read, and agreed to comply with the Trinity Health Code of Conduct.
How long have you been employed at St. Alphonsus?
5 years.
So you have signed this attestation approximately 5 times?
I believe so.
You turn to Exhibit 47, 1047, should be tab 47. Your Honor, I'll ask that Exhibit 47 be admitted. It's records from St. Alphonsus Health Systems that were provided in response to a subpoena ducis tecum. They provided a business records affidavit. This has been provided in discovery to the plaintiff. So I'd ask that 1047 be admitted.
Any objection, Mr. Herron?
Could I have one moment, Your Honor, please?
Fine.
Your Honor, this is again, a very long document that contains likely a lot of hearsay and a lot of irrelevant information. I wonder if there's a narrower part of the document that we can focus on?
I will be highlighting a few sentences. I think the entire document is relevant to show what the entire document is. It's not hearsay, it's policies and procedures that she just testified she has agreed that she has to comply with.
All right, well, the certificate that is the first page of the exhibit would seem to satisfy any authenticity or hearsay concerns that might apply here. Whether the document is it may have the narrow or limited relevance that was discussed in conjunction with Exhibit 1056. I'll overrule the objection. Exhibit 1047 is admitted. You may proceed.
Thank you. Dr. Corrigan, this is the code of conduct that you have agreed to abide by at least 5 different times. Is that correct?
Yes.
Can you turn to page 198? That's the bait stamps number. It's at page 4 of the document. And under the heading relationships with those we serve, you see at the end of that paragraph, it says we are all expected to, and then there's that bullet list of points.
Yes.
Can you read the very bottom bullet point on that list, please?
Provide care that is consistent with the ethical and religious directives for Catholic healthcare services.
And can you turn to page 201? Again, that's the bait stamps number, the document, page number 7. And could you read the very bottom paragraph, please, starting with the heading?
Ethical and religious directives for Catholic healthcare services, ERDs. The ERDs provide official church guidance and teachings on issues central to Trinity Health as a Catholic healthcare ministry. Colleagues, medical staff, and others working in Trinity Health are required to follow the ERDs. Consult your organization's mission leader if you have questions regarding how the ERDs apply to your work.
If you could look at Exhibit 1046, it should be tab 46. Your Honor, I'd ask that Exhibit 1046 be admitted. Again, this has the business records affidavit as policies from St. Alphonsus. This has been provided to plaintiffs through discovery, both the business records affidavit and the actual document.
All right. Any objection?
Your Honor, I'll make the same objection.
All right. I'll make the same ruling. I'll admit Exhibit 1046.
Thank you. Can you please turn to page bait stamp number 170, document number, page number is 8. The second paragraph, can you please read the first full sentence in the second paragraph?
First, Catholic healthcare ministry is rooted in a commitment to promote and defend human dignity. That is a foundation of its concern to respect the sacredness of every human life from the moment of conception until death.
Please turn to page 175. That's the bait stamp number. Document number is page 13, please. The third paragraph down, the one directly above the heading that says directives. So can you read the first sentence of that paragraph, please?
The inherent dignity of the human person must be.
I wanted you to do the paragraph above that.
Oh.
So just the first sentence of the paragraph above that.
When the healthcare professional and the patient use institutional Catholic healthcare, they also accept its public commitment to the Church's understanding of and witness to the dignity of the human person.
Now please read Directive 23 that you were starting.
The inherent dignity of the human person must be respected and protected, regardless of the nature of the person's health problem or social status. The respect for human dignity extends to all persons who are served by Catholic healthcare.
Please turn to page 178. It's page 16 of the document. Please read the first sentence of the first paragraph on that page.
The Church's commitment to human dignity inspires an abiding concern for the sanctity of human life from its very beginning, and with the dignity of marriage and of the marriage act by which human life is transmitted.
Please read the first sentence of the second paragraph, please.
Catholic healthcare ministry witnesses to the sanctity of life from the moment of conception until death.
Please turn to page 180, which is page 18 of the document. Please read Directive 45.
Abortion, that is, the directly intended termination of pregnancy before viability or the directly intended destruction of a viable fetus, is never permitted. Every procedure whose sole immediate effect is the termination of pregnancy before viability is an abortion, which in its moral context includes the interval between conception and implantation of the embryo. Catholic healthcare institutions are not to provide abortion services, even based on the principle of material cooperation. In this context, Catholic healthcare institutions need to be concerned about the danger of scandal and any association with abortion providers.
Please read Directive 47.
Operations, treatments, and medications that have as their direct purpose the cure of a proportionately serious pathological condition of a pregnant woman are permitted when they cannot be safely postponed until the unborn child is viable, even if they will result in the death of the unborn child.
Can you please turn to page 187? It's page 25 of the document. And if you could please read Directive 70.
Catholic healthcare organizations are not permitted to engage in immediate material cooperation in actions that are intrinsically immoral, such as abortion, euthanasia, assisted suicide, and direct sterilization.
Your Honor, at this point, I'm going to be referring to some policies from St. Al's that they provided to us, subject to the protective order, and I will be quoting those. So I think at this point, to honor St. Al's designation, I suppose we need to clear the courtroom, or?
All right, and just so we can make sure that plaintiffs, well, which exhibit is it?
It's actually not an exhibit. I'm going to be asking her direct questions about those policies.
All right, understood. And St. Alphonsus, is you're saying, has made a confidentiality designation as to these matters.
They have, that's correct.
Mr. Herron?
Yeah, Your Honor, plaintiffs can't waive St. Alphonsus' confidentiality designation, so I would agree if we're going to refer to that, then we'll need to close the courtroom.
All right, well, it would seem as though that's where we are. So what we'll do is we'll shut down the live stream for this portion of the proceedings, and we'll close this portion of the trial. So persons not here as a party or counsel of record or part of the court staff will need to make their exit from the courtroom, and we will permit you to re-enter when this line of questioning has concluded.
Your Honor, I do have, you said counsel Should I wait longer, or are we?
Let's see. Why don't you go ahead?
So Dr. Corrigan, I don't believe this is in the binder, so I will hand you a copy of it, or ask the bailiff to hand you a copy.
Jim, what is this?
I gave a copy to Mr. McCary.
Okay, thanks.
This is what's been marked as Exhibit 1057. Do you recognize this?
Yes.
What is this?
This is an email I wrote to a colleague at St. Luke's,
And who is that colleague?
John Wardell.
Is this a true and correct copy of that email that you sent to Dr. Wardell?
Yes.
Your Honor, I ask that Exhibit 1057 be admitted.
Other than redaction of the email address as just discussed, is there any objection?
No, Your Honor.
All right, Exhibit 1057 is admitted. The email address at the top will be redacted, and that'll be the official exhibit. Will have that portion blacked out.
Thank you, Your Honor. Do you need us to provide a redacted copy of that?
Clerk's happy to take care of that.
Okay, thank you. Dr. Corrigan, you testified that you would seek employment at another hospital if St. Alphonsus were to say that you could not provide life-saving or health-preserving abortions. Do you remember that testimony?
Yes.
And you filed this lawsuit on September 11th, 2023, is that correct?
Yes.
And on September 13th, 2023, you did in fact seek outside employment at another hospital, is that correct?
I just sent this inquiry to Dr. Wardell, asking to discuss possible opportunities.
Possible opportunities for employment at St. Luke's Hospital, is that correct?
Yes.
You wrote in your expert report that since the Dobbs U.S. Supreme Court decision was issued, that your practice has been drastically altered. Is that correct?
Yes.
Prior to the Dobbs decision, you performed approximately 1 to 2 abortions per year. Is that correct?
Yes.
How many abortions did you provide in the year 2022?
It's hard to recall an exact number, but it was probably around 3.
So that's more than the 1 to 2 abortions per year you testified about in your deposition. Is that? So did you do 3 in 2022 or 1 to 2?
Objection B.
I think it would help to have the question restated.
Yes, Your Honor. You testified at your deposition that you performed 1 to 2 abortions per year pre-Dobbs. Is that correct?
Yes.
But now you're saying that you did 3 in the year 2022?
Again, I can't recall exact numbers, but I do know that after the Dobbs decision, which was in the middle of the calendar year 2022, that my institution started receiving an increased number of patients.
So, Dr. Corrigan, that's not responsive to the question. You testified that you did 1 to 2 abortions per year previous to Dobbs. Is that right?
Yes.
Okay. But now you're saying you did 3 abortions in 2022? So did you do 3 in 2022, or is it or less than that, the 1 to 2?
I can't recall the exact number.
And you also testified at your deposition that after Dobbs went into effect, you continued to perform 1 to 2 abortions per year. Is that correct? I can show you your deposition testimony if you'd like to refresh your memory.
No, I believe I said that in my deposition, yes.
So you're affirming that, yes, you did say that at your testimony?
Yes.
How many abortions did you perform in 2023?
Again, I can't recall the exact number, but it was around 3.
And you were the physician who performed those abortions in 2023?
Yes.
And do you know how many abortions were performed in all of Idaho in 2023?
No, I don't.
Filed the required forms with the state of Idaho for those abortions that you performed in 2023 and 2022?
Objection, relevance.
Relevant?
Yes, Your Honor, it goes to the credibility and of her testimony that her practice has been substantially, drastically altered since Dobbs.
Well, I understand that to be the point of the whole line of questioning, but as far as whether any forms were filed, I guess that's the question that was objected to on relevance grounds.
So Idaho law requires that when you perform an abortion that forms be filed with the state of Idaho. In all of 2023, we'll have to get this through other evidence. In all of 2023, there were only 5 abortions performed in the entire state of Idaho. And so this goes directly to her credibility on those issues.
As far as whether she performed the abortions after Dobbs that she claims to have performed?
She's testifying that her practice has drastically altered. Her testimony is that the number of abortions she performs per year is consistent, pre-Dobbs and post-Dobbs. She's testified she's performed 3 abortions in all of 2025, or I'm sorry, in 2023. If that's accurate, then that means she's performed 3 out of the 5 abortions in the entire state of Idaho in 2023. And so I'm just trying to get to the credibility of her testimony.
Well, I think I understand the broader point. I'm a little fuzzier on what the forms have to do with it, but unless it's a check on whether she's actually performed whatever amount of abortions, number of abortions she says she's performed. In any event, I'll permit you to answer the question. I'll overrule the relevance objection, although I would say that the relevance is marginal at best.
Your Honor,
Yes.
I also object to lack of foundation, and it's also improper under Rule 404B1.
Get into whether Dr. Corrigan complied with an asserted legal requirement to file forms. Well,
And lack of foundation for those requirements.
the question, I suppose, presumed a requirement for the filing of forms after the performance of an abortion. So I'll sustain that objection. You're welcome to continue pursuing the line.
Your Honor, I'll ask that the court take judicial notice of Idaho Code 39261, which requires that any time an abortion is performed in the state of Idaho, that the physician file a form with the Idaho Department of Health and Welfare.
39-261.
I believe that's the citation. If it's not, I can get it, but
It does appear to be correct. Now, I think that the next step in this inquiry then would be an inquiry about about whether Dr. Corrigan is familiar with this requirement. So if you want to pursue that, go ahead.
Dr. Corrigan, you're aware that Idaho law requires that physicians file a form with the state of Idaho anytime they perform an abortion.
I am aware of that requirement. However, the requirement for the form actually does not include filing the form for certain abortions of the type of medication or induction abortion for which there are signs of fetal life after delivery. The rules specifically state if there are any signs of fetal life, such as detectable cardiac activity, that actually, for the purposes of that form, the state of Idaho does not consider it to be an abortion, and the form is not required, or it should not be filed.
So you're aware that there's a requirement to file the form with the state of Idaho?
Yes, however, again, the requirement for the form.
Corrigan, that was a yes or no question.
Okay, yes.
Did you file any forms for 2023?
Objection, Your Honor. I'm going to reiterate the 404B objection. No.
I don't think it matters at all if she filed a form or not when it was required, except in terms of a check on the testimony she's given as to whether she did perform abortions under the circumstances. So I'm going to allow the line of inquiry, despite its marginal relevance. But what I'm going to indicate is I'm going to consider it and not for really any purpose other than getting at how many abortions that are subject to the reporting requirement that Dr. Corrigan performed in the time period at issue. So. If you want, perhaps if you restate your question, it would help.
So Dr. Corrigan, it's a very simple question, yes or no. Did you file any forms for the abortions you performed in 2023?
I don't recall.
How many abortions have you performed in 2024?
I think 2 to 3.
And have you filed forms for those abortions?
Same objection.
All right. Well, same ruling, I suppose. You can answer.
So again, the situation, because there were signs of fetal cardiac activity after delivery, the form was not required to be filed.
So your testimony is that you've performed those abortions 2 to 3 in 2024, but it did not fall within the requirement to file a form, so you did not file a form?
Correct.
How do you define an emergent medical condition?
It is a condition where there is an acute change in the patient's clinical status.
Condition with acute change with the patient's clinical status?
Yes.
And you testified to numerous conditions yesterday, including, let me back up. You testified to numerous conditions yesterday. Would you consider all of those conditions to be emergent medical conditions?
Not all of them, no.
Would you include PROM as an emergent medical condition?
Yes.
placenta abruption, would you include that as emergency medical condition?
Yes.
Advanced cervical dilation,
Yes.
hyperemesis gravidarum?
Yes.
And then what were the ones that you would say were not emergent medical conditions?
When we were discussing other conditions like the diagnosis of cancer,
So cancer is not an emergent medical condition?
it depends on the clinical scenario. However, in many cases, the diagnosis is made after a test result is received and the patient is not, does not have an acute change in clinical status at the time the diagnosis is made.
So you said it depends on the clinical scenario, so you have to look at the patient, conduct whatever exams or tests you need, and then you make the determination at that time?
Yes.
So when you treat pregnant women, you must conduct an exam of the woman in order to determine the appropriate treatment options or recommendations. Is that correct?
Yes.
You would perform whatever tests you deem required or necessary. Is that correct?
Yes.
And each pregnancy is different. Is that correct?
Yes.
Each woman's individual situation will be different. Is that correct?
Yes.
And physicians must make complex, individualized determinations based on each patient's particular circumstances. Is that correct?
Yes.
And this complex, individualized nature of a patient's case, you can't just distill that down to a list that's generalizable for every situation. Is that correct?
Correct.
Part of the individualized determination, you testified several times during your direct, is to consider the ethical issues. Is that correct?
Yes.
One of those ethical issues you've talked about includes non-maleficence. Is that correct?
Yes.
And what is that?
The principle of do no harm.
So conducting an abortion poses a risk to the health and life of the mother. Is that correct?
No.
Well, yesterday you testified about some of those risks that abortions can have for women. So are you now contradicting your testimony from yesterday?
No.
I'm going to show you your deposition testimony. Turn to tab 22. This will be exhibit 1022. That should be your copy of your deposition testimony. So if you could turn to page 71 of your deposition testimony, and there's 4 pages on each page, so look at the little small one that should say page 71. So if you look on page 71, you're asked about complications of abortion, serious complications that could happen with abortions. You see that question?
Yes.
Jim, do you have a copy?
I gave you a binder of all the exhibits yesterday, so it should
Where is
be,
it in that binder?
tab 22. And so you testified that serious complications of abortions could include uterine perforation, injury to other organs, infections, hemorrhage, loss of fertility, and death, correct?
Yes.
Those would all be considered risks of having an abortion, is that correct?
They are risk of abortion procedures. However, they have to be taken in context with the clinical scenario. So
Dr. Corrigan, those are risks that are possible to happen if a woman has an abortion. Is that correct?
yes,
Those are risks that you would be advising patients about as potential complications if they were to have an abortion.
yes,
Testified yesterday that a procedural abortion has a risk of death about 14 times lower than continuing a pregnancy to term. Do you remember that testimony?
yes,
And that testimony, you're referring to the mother, correct? That the risk of death for the mother is 14 times higher if she were to carry a baby to term as opposed to her having an abortion. Is that right?
yes.
And what's the risk to the baby for an abortion? There's a 100% chance of risk of death of the baby if this abortion is successful. Is that correct?
At that time, it is medically considered a fetus.
But if an abortion is successful, the fetus dies. Is that correct?
Yes,
You've testified extensively about the medical ethics that you have to abide by. And you testified about ACOG. Can you, again, just to refresh the record, what is ACOG?
the American College of Obstetricians and Gynecologists.
And you were the chair of the Idaho session of ACOG, is that correct?
Yes,
Idaho section, I believe I said session, section. And so you consider ACOG to be a reputable organization, is that correct?
yes,
And you rely on the guidance and opinions that ACOG issues, is that correct?
yes.
Okay, I'm going to hand you a committee opinion from ACOG. Describe what this document is.
It is the ACOG Committee Opinion on Ethical Decision-Making in Obstetrics and Gynecology from December 2007, reaffirmed in 2016.
It was actually reaffirmed again in 2019, is that correct?
It does not state that on this document.
I'll hand you another document. So the first one I handed you was actually the PDF version of it. So this would be if you were to print it off just from the website. And if you look at that, it says it was reaffirmed in 2019. Is that correct?
Your Honor, I'm going to object that it seems like the council is trying to authenticate these documents.
Your Honor, it's to show that she relies on these documents, the ACOG. This all goes within the learned treatise exception.
No, she hasn't testified that she has seen these documents before, that she has seen this reaffirmation. None of that foundation is here.
You can continue trying to lay it, if you like.
Okay. The reaffirmation in 2019 is not important. So, Dr. Corrigan, do you have any reason to believe this committee opinion is not still valid or has been withdrawn by ACOG?
No.
And this is a committee opinion that you would rely on?
Yes.
Okay, so on the first page, there's a column in this, a heading in the second column says ethical framework and perspectives. Can you please read the first two sentences of that paragraph?
Your Honor, I'm going to object. This is not. Sorry, I withdraw the objection.
Okay.
Principle-based ethics. In recent decades, medical ethics has been dominated by principle-based ethics. In this approach, 4 principles offer a systematic and relatively objective way to identify, analyze, and address ethical issues, problems, and dilemmas. Number 1, respect for patient autonomy. Number 2, beneficence. Number 3, non-maleficence. And number 4, justice.
And this is what you've been testifying about through your testimony on the ethics that apply, is that correct?
Yes.
Okay, can you turn to page 3, please? In the second column, there's a heading that says ethical principles. You see that?
Yes.
Okay, and if you could read the second sentence, it starts with the major principles.
The major principles that are commonly invoked as guides to professional action and for resolving conflicting obligations in healthcare are respect for autonomy, beneficence, and non-maleficence, and justice.
Okay, and then if you could go down to the bottom of the page, the heading beneficence and non-maleficence. Could you read the first 2 sentences of that paragraph, please?
The principle of beneficence, which literally means doing or producing good, expresses the obligation to promote the well-being of others. It requires a physician to act in a way that is likely to benefit the patient.
Read the next sentence as well.
Non-maleficence is the obligation not to harm or cause injury, and it is best known in the maxim, primum non nocere, first do no harm.
Could you turn to the next page, please, page 4? And look at the box that says 1 case study, 5 approaches. You see that?
Yes.
The first paragraph, could you read the last sentence of that first paragraph?
Consider, for instance, how they might address interventions for fetal well-being if a pregnant woman rejects medical recommendations or engages in actions that put the fetus at risk.
Please read the first 2 sentences of the next paragraph.
A principle-based approach would seek to identify the principles and rules pertinent to the case. These might include beneficence, non-maleficence to both the pregnant woman and her fetus, justice to both parties, and respect for the pregnant woman's autonomous choices.
So you apply the principles of beneficence and non-maleficence to both the pregnant woman and her fetus, is that correct?
Objection
This opinion?
misstates what was just read.
All right, well, he's asking her view of that. I'll permit you to answer.
I have not recently read this entire document. I do know that based on my training and experience and my knowledge of other ACOG and SMFM documents, that the general principle is that the mother or the patient's life, health, and autonomy always take precedence over the life and health of the fetus.
Could you please read the first 2 sentences of that second paragraph again?
Objection asked and answered.
Already been read into the record. So you can ask another question if you like.
Testified yesterday regarding some recent guidance issued by the Society for Maternal Fetal Medicine regarding paraviable preterm pre-labor rupture of membranes. Do you remember that?
Yes.
And this was Plaintiffs Exhibit 590. Could she be handled Exhibit 590 from the plaintiffs?
That's fine. Would this be a good time for a break?
Sure, we can take a break now.
All right, let's plan on taking 15 minutes at this point. We'll resume with your questioning concerning Exhibit 590 after the break.
All rise. Council, you want to invite me?
All right, Dr. Corrigan, you may retake the stand. Good. You resume your cross-examination, Mr. Craig.
All right, thank you, Your Honor. Dr. Corrigan, could you please turn to Exhibit 590? It should be in the black binder there. And you testified extensively regarding this guidance that was issued by SMFM yesterday. Do you recall that testimony?
Yes.
And in this guidance, the Society for Maternal Fetal Medicine recommends that patients be provided with individualized guidance. Is that correct?
Yes.
And this states that in appropriate circumstances, expectant management is an appropriate form of handling PROM. Is that correct?
Not exactly.
So it's an appropriate form of treating PROM in at least some situations. Is that correct?
It is an option for the patient to decide, yes.
It is a medically appropriate option that a patient could decide to if she is diagnosed with PROM. Is that correct?
Yes.
And part of the individualized guidance that you have to provide to women will depend, like, and specifically women diagnosed with PROM, will depend in part upon the gestational age of the baby. Is that correct?
Yes.
And it will also depend in part on upon the residual amniotic fluid volume. Is that correct?
No.
Okay, could you turn to page B8 of this document, please? Okay, in first column, bottom of the first column, there's the heading. Do you see that heading there?
Yes.
Could you read the first two sentences, please?
When weighing the risks and benefits of expectant management versus abortion care after pre-viable or peri-viable PPROM, identifying clinical factors that predict outcomes could help individualize counseling. Among all baseline maternal and obstetrical characteristics, later gestational age at PPROM and higher residual amniotic fluid volume are most consistently associated with improved perinatal survival. Keep going.
No, that's good, thank you. And then could you look at the pie chart on page B6? You were asked many questions about this pie chart, so let me know when you're there. According to this pie chart, 16% of women who chose expectant management instead of abortion had a baby who survived, and the woman experienced no maternal morbidity. Is that correct?
Yes.
And in another 20%, the baby survived, but there was some form of maternal morbidity. Is that correct?
Yes.
So that would mean in 39% of the cases of women who chose expectant management, the baby survived. Is that correct?
Yes.
There's also 24% of women who had no maternal morbidity, but unfortunately the baby did not survive. Is that correct?
Yes.
So that means of the women who chose expectant management, 40% had no maternal morbidity. Is that correct?
Yes.
Could you turn to page B12 of this, please? Good. Look at the bottom of the first column, the second sentence. Can you please read that?
The second sentence from the bottom?
Sorry, the second sentence in that last paragraph. So the second sentence under the bottom heading, it starts with pregnant individuals.
I can't find what you're referring to.
Are you on page B12?
Yes,
Okay, first column,
yes,
very bottom, there's a heading that says future directions and conclusion.
yes,
And then second sentence in that paragraph immediately after, it starts with pregnant individuals.
pregnant individuals require counseling about all management options, including abortion care, and individuals who elect expectant management should be provided with the most realistic estimate of perinatal survival and morbidities based on the best available evidence.
And so this most realistic estimate of perinatal survival would include the information on page B6 that 39% of babies survived of women who chose expectant management.
Yes,
You also testified yesterday regarding a bulletin published by ACOG on gestational hypertension and preeclampsia. You remember that?
yes.
Okay, so that's Exhibit 255. I don't think it's in that binder. I had to give you my copy of that exhibit, so I apologize. I don't have one right in front of me. We couldn't find the other binder, but if you turn to page E243. And first full sentence of the last full paragraph. Can you read that sentence? It should start with continued observation.
Continued observation is appropriate for a woman with a preterm fetus if she has gestational hypertension or preeclampsia without severe features.
Thank you. I'm done with that binder now. If you could go to Exhibit 1049, it should be tab 49 in probably volume 3 of the white binders.
What number?
49. You recognize that exhibit?
Yes.
What is this?
This is a newsletter called Idaho Family Physician that is produced by the Idaho Academy of Family Physicians.
And if you could turn to the next page, it's marked as base number 1014. You see that?
Yes.
And what is that?
This is an article titled Update on Patients with Pre-Viable PPROM that I wrote.
That's true and correct copy of the article that you wrote.
Yes.
Your Honor, I'd ask that Exhibit 49 be admitted.
Any objection?
No.
All right, exhibit,
Sorry, can I say something? It has my email address on it.
okay, understood. So this, and where is your email address within?
On the bottom right.
Your Honor, plaintiffs did remove the confidentiality designation of this in an email they sent to us, but I do not object to having her email address redacted.
Okay, understood. Exhibit 49, 1049 that is admitted with the exception of Dr. Corrigan's email address, which the clerk will black out.
And why did you write this article?
I wanted to make physicians in Idaho aware of recent publications from the HHS secretary regarding pre-viable PPROM.
And this is related to the EMTALA case that you were testifying about yesterday.
Yes,
In fact, you submitted a declaration in support of the United States position in that case. Is that correct?
yes,
That was arguing that Idaho's law should be subject to an injunction and not be enforced. Is that correct?
yes, in regards, as related to EMTALA cases.
And in this article, you write that patients should be counseled regarding the risks and benefits of expectant management in order to treat pre-viable prom. Is that correct?
Yes, I believe so.
And you wrote that patients should be counseled regarding the risks and benefits of immediate delivery by way of termination, by induction of labor, or dilation and evacuation. Is that correct?
Yes.
What is a dilation and evacuation procedure?
It is a surgical procedure to remove products of conception from the uterus in the second trimester.
You mean to remove the baby or to remove the fetus?
Remove the fetus and the placenta.
And a dilation and evacuation abortion is commonly used in second trimester abortions. Is that correct?
Yes.
And in a dilation and evacuation procedure, a doctor must first dilate the cervix. Is that correct?
Yes.
How is that done?
It's generally done with laminaria.
What is that?
Those are dehydrated seaweed sticks that are compressed, and speculum is placed in the vagina. A cervical block is performed with lidocaine for anesthesia, and using usually a ring forceps, the seaweed sticks are inserted into the cervix.
Process of dilating the cervix can sometimes take a day or two. Is that correct?
Yes.
And then once the cervix is dilated, a doctor then inserts grasping forceps through the woman's cervix into the uterus to grab the fetus. Is that correct?
Well, that is during the actual D&E procedure.
And then the doctor grips a fetal part with the forceps and pulls it back through the cervix and vagina, continuing to pull even after meeting with resistance from the cervix. Is that correct?
No.
Okay, so that's a quote straight from the United States Supreme Court. So the Gonzalez versus Carhart case, 550 U.S. 124. So are you saying the U.S. Supreme Court is not accurate in that?
Objection. Counsel's testifying about what's in a case before the witness hasn't presented the witness with anything. I'm not really sure even what the relevance is.
I don't think we can expect the witness to comment on U.S. Supreme Court decisions. But you're welcome to continue inquiring about what the procedure entails.
So when they're pulling the, so let me back up. The doctor inserts grasping forceps into the woman's cervix. Is that correct?
Into the uterus, yes.
Okay. Into the woman's cervix and then into the uterus?
Yes.
Okay. And using the forceps to grab the fetus, is that right?
Yes.
And you pull the forceps back out through the uterus and out through the cervix, is that correct?
Yes.
And you continue to pull until you pull out a fetal part, is that correct?
Yes.
And that causes the fetus to tear apart, is that correct?
Yes.
And a leg might be ripped off the fetus as it is pulled through the cervix and out of the woman, is that correct?
Objection. Relevance, Your Honor.
Your Honor, dilation evacuation is a barbaric and gruesome procedure. This goes directly to that. State of Idaho has a compelling governmental interest in prohibiting.
I'm aware that that's a line of defense you're pursuing, and it's germane to that defense. It's not. I'll permit you to continue. It's obviously that there's only so much more we can do to discuss what the procedure consists of, but I'll overrule the objection to that question.
As you're pulling out the fetus piece by piece, you continue it until the fetus is completely removed. Is that correct?
Yes.
Might take a doctor 10 or 15 passes with the forceps to evacuate the fetus in its entirety. Is that correct?
That's possible, yes.
And once the fetus has been evacuated, the placenta and any remaining fetal material are suctioned or scraped out of the uterus. Is that correct?
Usually the placenta is also grasped with the forceps, and then aspiration, curettage is performed.
The aspiration and curettage, that would be where they suction out or scrape out the remaining products of conception, to use your term. Is that correct?
Yes.
The doctor then must examine the different parts of the fetus to ensure that the entire fetal body has been removed. Is that correct?
Yes.
Can you turn to Exhibit 1052, please? Do you recognize this?
Yes.
What is this?
This is a series of text messages that I had with Maria Palmquist.
Who is Maria Palmquist?
She is a maternal fetal medicine physician.
Where does she work?
She currently works part-time at St. Alphonsus and several other hospitals.
So she's one of your colleagues at St. Alphonsus then?
Yes.
Your Honor, I ask that Exhibit 1052 be admitted. This is one of the text messages that we have stipulated that it's authentic.
Is there any objection?
Your Honor, this does clearly contain hearsay.
In terms of statements made by Dr. Corrigan's colleague, is that right? And Mr. Craig, you're content, as with Exhibit 1051, admitted during Ms. St. Mitchell's testimony, that the statements by the colleague in this instance be considered only for their effect on Dr. Corrigan and as context for what Dr. Corrigan said.
That is correct, Your Honor.
All right. On that condition, the exhibit 1052 is admitted.
I'd also ask that this is another exhibit that plaintiffs have designated as confidential. I'd ask that the confidentiality designation, the court overrule that and remove the protections from the protection order.
Let me know your position on that, Mr. Herron.
Your Honor, my concern with this, with removing the confidentiality of this document is that it does refer to the names of other people who are not necessarily a part of this case, and I believe that's why we've designated this as confidential.
Names of other people are not considered protected information, Your Honor.
These are very sensitive topics, and for individuals' safety, we've made an effort to ensure that people who have not willingly come forward in this case, that their names are not disclosed.
I suppose, let me ask whether I see at least a couple of other instances in which other folks' names are mentioned. Is there anything significant to the case about the names?
Yes, Your Honor.
All right. Well, why don't we do this? Can you complete whatever is left of your cross-examination, leaving this topic until the end so that if we need to clear the courtroom again, perhaps we can ensure that we only do that once.
Well, Your Honor, I think that this text message change goes directly to Dr. Corrigan's bias and purposes for bringing this lawsuit. It also goes to several other of our defenses. This is obviously a very public case. There's significant interest in here. There's nothing in here that is protected. There's no social security numbers, there are no dates of birth. Plaintiffs have already redacted out telephone numbers. There's no email addresses. There's no personally identifiable information. I think it would violate the terms of the court's protective order for this to remain confidential. And so I'd ask that the court remove the confidentiality designation. I do plan on asking direct questions related in here, and it's not something that I can do pick and choose. This is confidential, that's not.
Can you, I guess, cite me chapter and verse as to how this falls within the protective order?
I don't have the protective order in front of me, Your Honor, but names are the most PII that you can get, personally identifiable information of individuals who are not, I mean, this is a uniquely sensitive case, sensitive topic, and identifying the names of individuals, I believe, is protected by the protective order, which is why we marked this as confidential, of individuals who are not a part of this case.
All right. Well, it seems to me that according to the protective order, the fact that that folks' names are used does not make it categorically beyond the bounds of what is protectable under the protective order. Now, I guess it's unclear to me what the significance of this document is and what the significance of any of the referenced people are, what the significance of any of the referenced people is.
Your Honor, if I may point you to E at the bottom of page 2, documents that, and then toward the end, may subject a third party to financial, associational, reputational injury, jeopardy to the person's safety or privacy. This is certainly a privacy issue for those third parties.
Your Honor, the names that are mentioned in here, I'm not sure how far I can go without potentially violating the stuff, but I mean, I would love to make more argument. I just don't want to risk violating the court's protective order.
I understand what you're saying. Can we talk to the bench, or are they going to be broadcast on the internet? What we'll do is have a bench conference. The live streaming will be paused during that proceeding. So if council 52, after discussion during the bench conference, is admitted subject to the redactions council and the court discussed and agreed upon during the bench conference. Of course, the matters subject to the redaction ought not themselves be mentioned during succeeding questioning by Dr. Corrigan, but you're welcome to otherwise inquire.
Thank you, Your Honor. Dr. Corrigan, if you could turn to the text message that was sent on March 31st, 2023 at 5:54 p.m. There were two text messages with that exact date and time. Do you see those?
Yes.
And could you please read those two text messages?
Am I supposed to read the names, Your Honor?
That name is not one that's being redacted, so you can read that one.
Okay. The hospitals have to use their full weight on this one, or else it is going to shut everything down, which is maybe what needs to be done temporarily, and the legislature can call themselves back into session and give us a much more protective bill. Melissa Wintrow told me yesterday that we need to let them, quote, burn it all down.
Who is Melissa Wintrow?
She is an Idaho state senator.
And this is all in the context of abortion, is that correct?
These text messages were in response or in reaction I was sharing with my colleague regarding the memo that Attorney General Labrador wrote stating his opinion was that referrals for abortion was he categorized as a type of assisting with abortion. So we were discussing how physicians working in reproductive health were going to care for their patients if we could not even basically discuss abortions with patients or discuss that they are available in other states. And she was alluding to that another MFM physician and the genetic counselor were.
Okay, Dr. Corrigan, I think my simple question was this was all in the context of abortion, and I think you've answered that in the affirmative. Is that correct?
Yes.
Could you read the text message that Ms. Palmquist sent to you on March 31st, 2023 at 6:14 p.m., please?
They are doing a damn good job of trying to burn it down. What educated person would choose to live here?
So when you're talking about the text message from where you refer to burn it all down, that's the message you originally sent. Burn it all down, you're referring to shutting down the hospital system. Is that correct if you go back up to that first text message you sent?
Basically, not having obstetrical care available in this state.
On March 31st, 2023 at 8:49 p.m., you sent a text message, and that contains a link to a website. Is that correct?
Yes.
That is a news video. Is that correct?
Yes.
And then at that same date and time, you said this is a story I mentioned. So that was a story that you had mentioned to Dr. Palmquist?
Yes.
You turn to Exhibit 1053, please. And the title on this document matches the title that is in that text message with the link to the news article. Is that correct?
Yes.
And if you could look at Exhibit 1054. And Exhibit 1054 has a video on a thumb drive, but there's also a website there kind of on the slip sheet. That appears to be, can you compare that website with the website that's in the text message that you sent? And let me know if those appear to be the same.
Yes, they're the same.
And so Exhibit 1053 and Exhibit 1054 would be the news article and the accompanying video that you had sent to Dr. Palmquist. Is that right?
Yes.
I want to ask that Exhibit 1053 and 1054 be admitted.
The objection.
Your Honor, as to 1053, I'm going to object on hearsay grounds, and then as to 1054, hearsay as well as the fact that she hasn't seen the video. She hasn't watched what's on the CD.
All right. What's the response to the hearsay objection?
So it's not being offered for the truth of the matter asserted in those videos, but it's very relevant to show the context of the remaining text messages. You can't understand the context of the remaining text messages if you do not observe the video and the article.
Okay. I'm going to refuse admission of those exhibits. This is a trifling point in my judgment. It will not move the needle. Let's move on.
Well, Your Honor, this is quite critical. There is a compelling governmental interest in preventing discrimination on the basis of disability. And here Dr. Corrigan is directly saying that, making disparaging comments about people in a news article based upon their disability. This is directly relevant to that compelling governmental interest and shows the need for it, shows Dr. Corrigan's bias and her motivations for bringing this lawsuit.
Denial of admission of this evidence does not prevent the state from making pursuing the line of argument that compelling government interest exists. This does not materially further that point. Let's move on.
Dr. Corrigan, could you read the text messages starting March 31st, 2023 at 9:15 p.m. Through the remaining exchange, please?
Starting with which one?
March 31st, 2023, starting at 9:15 p.m.
Your Honor, I'm going to object on relevance. You just said to move on from this line of questioning.
All right. Well, the document itself is now in evidence, and if the question is simply, will you read the balance of it, I'll permit that. The document's in evidence.
That's the question. Can you please read those text messages?
All the way to the end?
Yes, please.
Not exactly thriving quality of life. It's not the politician's place to make this decision for everyone. Life altering for a family to care for a child with so many needs. And if that was their oldest, can you imagine the impact on the younger children? Exactly. I thought their emphasis on quote unquote thriving was so deceiving. I also didn't like the way the journalist skimmed over her challenges and glorified the situation, not a good way to educate the public. And who will take care of her when her parents die? Or how it will be much harder to care for her when she is too big to carry around like a baby. Exactly. My mom worked in special ed for 40 years. And I used to be a teacher's aide in her classes during summers in college. Very difficult when they are adult size and still in diapers and have feeding tubes.
And that last text message was one that you sent, is that correct?
Yes.
Thank you. I don't have any other questions, Your Honor. Of course, reserving the court's refusal to admit those two exhibits. Of course, reserving the right to challenge that.
Sure, understood. You made an offer and it was refused, and so it's preserved for the record. Any redirect, Mr. Herron?
Yes, Your Honor. Yes. Dr. Corrigan, could you pull up Defendant's Exhibit 1057? Top 57 in the binder.
Volume is it in?
1057, I believe, came in today, not in a binder.
Should be a copy of it up
Somewhere, but
It's one of these.
looks like she has it at this point. So.
You have the document?
Yes.
Why did you write this email?
Because I was frustrated with the response from some individuals in St. Alphonsus administration that they said to me after I filed this lawsuit.
And at the end of the first paragraph, could you just read that last sentence?
I don't think my family and I are ready to give up on Idaho quite yet. So I would like to discuss with you what types of employment opportunities are available to me at Luke's.
And could you also read the first sentence of the next paragraph?
As you probably know, there's an ongoing mass exodus of MFM and OBGYN providers from ALS. I'm sure that Luke's, OB, and MFM...
You can stop there at the end of that first sentence. What do you mean by that?
Direct relevance. This goes against the court's earlier argument that that's not relevant.
Recognize the document is in evidence, but we've discussed this twice at this point, and that's not the issue in the case. It's just not.
Defendant opened the door, so I was walking through it, but I will certainly respect that ruling, Your Honor.
All right.
And then the third paragraph, could you read the first sentence, please?
I also am very interested in participating in the reinitiation of abortion services in Idaho when the laws are changed. This has become a new goal of mine, along with...
You can stop there, sorry. And then the last sentence, you say, I would need to be part of the St. Luke's team. Is that correct?
Yes.
What did he mean by that?
As the court has heard, St. Alphonsus has restrictions on for which circumstances abortions can be provided at that institution. I personally, as a physician, do not share those same viewpoints. And as we have seen, it is difficult for patients who are denied abortion care here in Idaho to have to travel out of state. And I know there are two components. One is the legal situation, and number two is abortion access. So even if a state, even if certain types of abortions for certain circumstances are legal in the state, if there are no physicians trained and willing to provide those services, then there is no access in the state, and the patients would still have to seek care out of state.
So is this email, you were writing to inquire about opportunities at St. Luke's, is that right?
Yes.
And if the court were to allow you to provide abortion care that you are currently not allowed to provide at St. Alphonsus, what would you do?
Objection calls for speculation.
You can answer.
I would contact the leaders of women's services at St. Luke's and again discuss with them employment opportunities.
Are you aware of whether St. Luke's is in need of obstetricians and gynecologists?
Objection, relevance.
Overruled. You can answer.
Is my understanding that yes, they have several open positions currently.
Right. Back to the binder, if you could turn to tab 46, which is Defendant's Exhibit 1046. Turn to page 181 at the bottom, or page 19.
It's tab 46?
Yes, tab 46, page 19 at the bottom.
Okay.
Read paragraph 47.
Operations, treatments, and medications that have as their direct purpose the cure of a proportionately serious pathological condition of a pregnant woman are permitted when they cannot be safely postponed until the unborn child is viable, even if they will result in the death of the unborn child.
Under what circumstances does paragraph 47 allow you to provide abortion care?
Situations involving emergent medical conditions or other situations such as patients diagnosed with cancer that would not be able to receive recommended treatment while still pregnant.
Does St. Alphonsus consider those procedures to be abortions?
So in medical terms, those procedures are abortions, and all medical providers at St. Alphonsus use that terminology. However, the U.S. Council of Catholic Bishops, who wrote this document, consider those not to be abortions in the moral sense. So they use this terminology of operations, treatments, and medications. However, the physicians in Catholic healthcare understand that is medically an abortion.
Yesterday, you were testifying about euphemisms that you have heard used for abortion, correct?
Yes.
Are some of those euphemisms in paragraph 47?
Yes.
Could you turn to paragraph 47? Excuse me, I'm sorry. Tab 47, which is Defendant's Exhibit 1047. Page 201 at the bottom. Do you see the paragraph about EMTALA, the two paragraphs?
Yes.
And then the second paragraph there, the third line down, could you start with reading with "We follow EMTALA"?
We follow EMTALA. We do not delay medical screening or necessary stabilizing treatment when a patient is in an emergency or in labor. We do not admit.
That's good, thank you. And then the sentence that immediately preceded that, starting with Trinity Health.
Trinity Health is committed to providing emergency medical care when we have the capacity and capability.
You're allowed to provide EMTALA abortions or abortions required under EMTALA at St. Alphonsus?
Yes.
In fact, aren't you required to provide those?
Yes.
Do you have the ACOG committee opinion in front of you that was given to you earlier? It's not in one of the binders.
Yes.
You turn to page 3. Could you read the paragraph with the heading "Respect for Autonomy"?
Autonomy, which derives from the Greek autos, self, and nomos, rule or governance, literally means self-rule. In medical practice, the principle of respect for autonomy implies personal rule of the self that is free both from controlling interferences by others and from personal limitations that prevent meaningful choice, such as inadequate understanding. Respect for a patient's autonomy acknowledges an individual's right to hold views, to make choices, and to take actions based on her own personal values and beliefs. Respect for autonomy provides a strong moral foundation for informed consent in which a patient, adequately informed about her medical condition and the available therapies, freely chooses specific treatments or non-treatment. Respect for patient autonomy, like all ethical principles, cannot be regarded as absolute. At times, it may conflict with other principles of values and sometimes must yield to them.
Why is autonomy so important to you?
In my medical training, I was taught to respect patient autonomy above all else. That if a patient was deemed to have the capacity to make medical decisions for themselves, that I needed to respect their choices and should not treat them against their will.
Earlier, you were asked about an exhibit that mentioned a news article about trisomy 18, correct?
Yes.
Whose decision is it about, from a medical ethical standpoint, whose decision is it about whether to continue that pregnancy?
I'm going to object. She can't testify as to the ethicals for everybody else. I mean, certainly for herself she can, but not for everyone else.
The question was from the standpoint of medical ethics? All right, phrased in that way, I believe the objection would not continue to apply. As I understood the objection, it was ethics generally, and those aren't universal to, those are different for different people. if it's rephrased in that way, is that no longer objectionable?
If it's rephrased as to her interpretation, the ethical guidance, I would not object.
All right, go ahead and rephrase.
Based on your understanding of medical ethics, whose decision is it whether to continue a pregnancy after a diagnosis of trisomy 18?
The patient's decision.
Is it unethical to provide an abortion to a patient with a lethal fetal diagnosis?
No.
You were asked earlier about the number of abortions you provided each year. Do you remember that series of questions?
Yes.
I believe you testified that you provided more abortions in 2022 than in 2021, to the best of your recollection. Is that right?
Yes.
Why did you?
I believe that mistakes her testimony. I don't think I asked about 2021.
Well, I believe you asked about years prior to Dobbs, which would be 2021, among other years. And I believe the testimony was that there were potentially 2 or 3 abortions that Dr. Corrigan performed in 2022. So I'm gonna overrule the objection.
Why did you provide? Why did the number of abortions that you provided after Dobbs increase?
Because after the Dobbs decision, there was an increased number of patients arriving at our hospital with emergency medical conditions that should be offered abortion care for stabilizing treatment that were denied care at other hospitals in Idaho.
If you could turn back to tab 52 in your binder. Let me, I may come back to this, but I'm going to not ask about this document at the moment. You were asked a series of questions about D&E. Do you remember that?
Yes.
In the second trimester, if a patient needs an abortion, what's the alternative to a D&E?
Medication or induction abortion.
What is safer for the pregnant patient in terms of medical risks, D&E or an induction abortion?
A D&E.
Why?
Because with induction abortions, number one, there's the risk of failed induction, just that the uterus and the cervix do not respond to the medications provided, and that the fetus is not expelled spontaneously in its entirety. There's also approximately 20% risk of retained placenta, which can often lead to hemorrhage, requiring a D&C surgical procedure, And there's also risk that the induction abortion can take multiple days and that an infection can develop in that time.
Your Honor, I may have a few more questions. I recognize that it's around lunch. I'm not sure whether.
I was hoping to finish with Dr. Corrigan's testimony before we break.
I'd ask that the council be instructed to move on. We're not taking a break right now.
All amount of patience for that, but not unlimited.
Thank you, Your Honor. I thank you for your indulgence. I believe we have, well, turning back to tab 52 in your binder, you referenced in your explanation of about what prompted you to write these text messages. You mentioned a letter from Attorney General Labrador. Is that correct?
Yes.
We do not have a hard copy of that letter, but we have a provisional, or we can put it on the screen if it's okay with the court, and have her, identify it as provisionally, as we can provisionally mark it as Plaintiff's Exhibit 597 and provide a hard copy after lunch.
I'd object. That goes beyond the scope of cross-examination. It's irrelevant, and it's hearsay, and it's beyond the scope of the question that was asked that she answered.
Well, the letter itself was well publicized at the time it was issued, and the doctor has described it in her testimony. And I guess from my standpoint, that seems to be an adequate way of covering the topic.
Did you fear prosecution because of that letter?
Yes.
Your Honor, I understand your ruling, but we do have a copy of Plaintiff's Exhibit 597. We offer it into evidence. I don't believe it's hearsay. It is not being offered for its proof, or for the proof of the matter asserted. If you do not want to admit it for the reasons, I'm not going to ask any additional questions. We do want to get it into evidence. If you're, so I'll stop there.
All right, understood. Mr. Craig, you're welcome to restate whatever objections you have.
Yeah, same objections. It's hearsay. It's beyond the scope of cross-examination, and and I think this is very much getting into the stuff that at best is, it's not even related to anything. She's testified to her the context of the text messages, and I don't think we need the actual letter for that.
All right, well, I'm not sure whether it's proper to view the letter as hearsay, given that it was written by general in the course of discharging an official duty. So may not be hearsay. It's certainly not beyond the scope of cross-examination, because cross-examination encompass these text messages and the motivation for writing them. Now, as to I guess the more general topic of whether it is relevant to anything. It seems to me that, again, that the witness has testified to the letter's existence and its resulting motivation or resulting effect on her, and I'm just inclined to leave it alone at this point. So I'll deny admission of the document at this point.
Your Honor, could we lodge the exhibit as an order?
Absolutely. That is fine. What number did you give it?
Plaintiff's Exhibit 597.
All right. That's fine. The clerk will retain a copy for the record.
I have nothing further.
All right. Do you have anything else for this witness?
Yes, Your Honor. I'll be brief. Famous last words for an attorney. Dr. Corrigan, could you turn to Exhibit 46, please, or 1046?
Is it in this one?
It would be in the third, volume 3 of 3.
Okay.
And then you could turn to page 19. And your counsel had you read Directive 47, and you testified that, well, the Catholic bishops don't define those treatments as abortion. You remember that testimony?
Yes.
But they actually define abortion in paragraph 45, just two above, correct?
Yes.
And abortion is defined as the directly intended termination of pregnancy before viability or the directly intended destruction of a viable fetus. Is that correct?
Yes, that is how the bishops define abortion. That is not how the medical profession defines abortion.
Yes, I understand. You testified that at St. Al's that you are allowed or required to perform abortions that are necessary under an EMTALA. Is that correct?
Yes.
And that's because the United States government has threatened hospitals for all loss of Medicaid funding if they don't provide abortions in those emergency situations. Is that correct?
Objection, lacks personal knowledge.
Yes. That's because the United States government has threatened hospitals with loss of Medicaid funding if they don't comply with that interpretation of EMTALA. Is that correct?
The objection was lack of personal knowledge. I would say you can answer if you know. If you know the answer.
I would say that any abortion that would fall under the EMTALA umbrella also falls under ERD number 47.
The United States government has, in fact, threatened hospitals with the loss of their Medicaid funding if they don't comply with their interpretation of EMTALA. Is that correct?
Yes.
You testified that patient autonomy is the most important medical ethic for you. Is that correct?
I don't believe I said it is the most important. It is, they are all important.
I believe your language was that you were taught to place autonomy above all else. Do you recall that testimony?
Yes.
So if a patient comes in and asks to have a medical procedure that there is no need for that medical procedure for any reason, would you perform that medical procedure?
No.
So in that case, you would ignore patient autonomy?
No. There are competing ethical principles there because performing a procedure.
You've answered the question. It was a yes or no answer. Thank you. I don't have any other questions.
All right.
Very brief. What was the rest of your answer to that question?
Um,
Beyond, I'll object beyond the scope of cross. It was a direct yes or no question, and, you know, she answered no, and that's the answer.
Overruled, you can answer.
It is unethical to perform a procedure that is not indicated because that would harm the patient because there are inherent risks to any procedure. And so that would violate the ethical principle of non-maleficence or do no harm. Also, patients, the medical profession is trained to offer treatments to patients that are within the standard of care for their diagnosis and their current situation. If the patient is requesting a procedure or treatment that is not within the standard of care for their current medical condition, there is no physician that would agree to that treatment because then they would be not acting within the standard of care.
Do you recall being asked about the definition of abortion, which was in paragraph 45 of the Catholic directives?
Yes.
And that definition says that a procedure whose, quote, sole immediate effect is the termination of pregnancy as an abortion, before viability as an abortion. Is that correct?
Yes.
If a patient has a high-risk pregnancy and the abortion is being provided to save the patient's life or protect the patient's health, is the termination of the pregnancy the sole effect of the abortion?
No.
All right. Thank you, Dr. Corrigan. You may step down. Probably now is as good a time as any for an afternoon break, lunch break. We can take that now, and we'll be in recess until 1:30. We'll have 3 hours of court time left after that. We'll be in recess.
All right.
All right, plaintiffs may call their next witness.
Your Honor, before we do that, I have one thing. There's just a small portion of Dr. Corrigan's deposition transcript I would like to move for admission. I can either do that now or wait until plaintiffs rest entirely, and we can do it at that time.
It seems appropriate, Your Honor, to just be, that counsel offered during their case in chief.
All right. I mean, I suppose it's, I'm not sure it matters, but
I'll go ahead and do it now then. So this is Exhibit 22, I believe. Yeah, Exhibit 22 be page 19, line 23 through page 20, line 5. And then again, page 21, line 13 through line 16.
22.
Exhibit 1022.
These excerpts.
all right. Well, it's certainly a topic that was covered in the testimony given here in open court. It seems to me that this testimony in this deposition, these deposition excerpts, is more or less consistent with the testimony offered in open court. But I guess I don't see any particular loss or damage that is done by including it in the evidentiary record for decision on the matter. So I'll go ahead and, of course, it's a deposition of an opposing party. It can be used for any purpose, subject to the rules of evidence, of course. It seems to me that this is not inappropriate. So of Dr. Corrigan's deposition, Exhibit 1022. Page 19, line 23 to page 20, line 5, and page 21, lines 10 to 16 will be considered part of the evidentiary record for decision. All right. Now, Ms. Kiesig, you were going to call a witness. Is that right?
Yes, we'd like to proceed with calling the custodians of record in the case, so I'll begin with the records custodian for St. Alphonsus, Kaylin Coltrane.
All right.
I'd note that this witness was not disclosed in discovery. And I'd ask that she not be allowed to testify.
I believe that we disclosed records custodians on the witness list, records custodians as necessary.
All right. And when you say not disclosed in discovery, are you referring to the witness list itself or to some sort of discovery, like some sort of interrogatory or something?
So this is the first time we have heard her name. We have asked for identity of those with knowledge. They had a requirement to provide a witness list at the attorney's conference. They had a requirement to provide a witness list before the court. For the pretrial conference, we have never heard this witness's name until right this second when she called the name.
All right.
So we disclosed that we would call records custodians as necessary. Ms. Coltrane wasn't named because when we issue the subpoena, we issue it to the hospital and then they identify the correct person to send to authenticate the records. And so that's what we've done in this case. When it became necessary to call Ms. Coltrane to court, we inquired of the hospital, and the hospital identified Ms. Coltrane as the person who would authenticate records, but we had disclosed previously records custodians as needed.
All right. And what are the, I guess, which exhibits are at issue?
So, Your Honor, this goes back to the issue raised at the very start of trial, that we had disclosed medical records. Ms. Coltrane will speak to the medical records for both Ms. Adkins and Ms. St. Mitchell. We produced this last weekend a complete set of medical records for each of them, which were certified medical records, produced by the hospital and certified by Ms. Coltrane. And she is prepared to testify that the excerpt that we wish to offer into evidence is a subset of those medical records that were produced, but additionally, to compare those to what was originally produced in discovery, to compare those documents to the extent that they correlate, and to establish that.
So, Your Honor, again, they have an obligation to provide stuff to us in a timely manner in discovery. From the very beginning of the case, we asked for medical records, and from their disclosures, we told them that they were not complete. And then the eve of trial, 10:30 on Sunday, before trial was supposed to start till on Tuesday, they dropped hundreds of new records that were never disclosed. Some of the records that they've provided to us have different redacted, that were in the original tranche of stuff that they provided to us. They have different redactions than what they've were provided. And I mean, it's just unreasonable for them to be able to use evidence that, you know, they're ambushing us literally with thousands of documents, thousands of pages of documents, hundreds of pages of new stuff on the eve of trial. This is highly inappropriate, and then they try and do it with witnesses that they have not previously disclosed.
Witness going to authenticate previously produced documents or the newly produced documents?
She's going to authenticate the newly produced documents, but then compare them to the previously produced documents to show that they correlate to what was previously disclosed.
What way? What will the testimony be?
So she will testify that I have made available to her what was previously disclosed and that she was able to do a comparison of those documents, and she'll be able to testify that those documents correlate to what was disclosed this last weekend.
What do you mean by correlate?
She can't, obviously because they were different productions, you know, they are not necessarily copies of what was produced previously, but that she has done a line-by-line comparison of those documents is my understanding. And she will be able to testify to any differences identified between what was produced originally and what has been certified in the medical record production now.
Can she authenticate the ones that are not clouded by untimely production?
So what we seek to admit into evidence are those records that were produced recently, but she will be able to establish that they are similar, if not entirely directly correlated to the records that were produced before.
All right. Well, I guess if I don't understand why we are where we are. I don't understand why if the witnesses, if there are documents that are you're characterizing as similar or that correlate to more recently produced documents that were produced, the more recently produced ones having been produced not in timely fashion. what is the, I guess, what's the problem with having someone authenticate the ones that you produced on time?
Well, so the process, I would say, of authenticating those documents would simply be that she can look at those documents and say that those appear to be the same as medical records that she has certified.
All right. So then, I guess, why aren't you offering then the ones that the ones that were produced on time?
Your Honor, our thinking was to be able to produce the ones that have certificates of authenticity.
You have a live person here who, that's the same function.
And I think that in this case, at least with the St. Alphonsus records, that it isn't clear that there wasn't a certificate of authenticity with those records, that they were simply requested by a patient, and she can speak to that process of a patient requesting those records. And if that is sufficient to authenticate those records for this court, then we would ask to admit those.
All right. Well, if there is something you can accomplish with this witness that is an effort to authenticate documents that you produced in timely fashion, not the ones you produced on Sunday, you're welcome to give it a go. But at this point, I'm just going to direct that be the focus rather than the provisionally excluded documents that were produced on Sunday.
Understood.
All right. The clerk has an oath to administer. Thank you for your patience standing there listening to all of that.
I'll renew my objection that this witness was not timely disclosed. We literally did not find out her name until just, a few minutes ago when she was called. And so there's another violation of the discovery order and the court scheduling order in that respect.
All right, understood. I guess I would generally consider the disclosure of a records custodian by category rather than by individual name to be adequate. My understanding is the witness is simply going to testify in a way that authenticates documents and not in a capacity of a records custodian and not otherwise as some other sort of fact witness. Go ahead.
Thank you, Your Honor. Ms. Coltrane, would you state your name for the record?
My name is Kaylin Coltrane.
Spell your last name.
Yes. Coltrin.
And what is your occupation, Ms. Coltrane?
I am Health Information Management Operations Manager at St. Alphonsus Health System.
And as part of your position, do you deal with medical records?
Yes.
Yes. In what way?
In every way. That is the department I work within. So within the production of records, from the point of their initial creation in the hospital, and then all the way through to the point of releasing records to patients, other care facilities, subpoenas, and that sort of thing.
Did you respond to a records request in this case?
Yes.
And what did you do in response to that request?
We fulfilled it based on what was requested.
Ms. Coltrane, you have some binders in front of you. I'm going to ask that I think it's that first binder that you just touched, that you open to the tab marked with Plaintiffs Exhibit 591.
Okay.
Do you recognize these documents as documents that you gathered in response to the request for medical records?
Yes, these are the records that were produced.
And are these records that pertain to Jennifer Adkins?
Yes, they are.
And I see you flipping to the certification page. So you certified these medical records. Is that correct?
Let's see. Yes.
And that certification indicates that these were records that were kept in the course of a regularly conducted activity.
Objection leading.
Sustained.
What does that certification indicate?
The certification indicates that these are the records, to the best of our knowledge, that are kept during the course of care for patients.
But what certification is that? I'm sorry, where are you referring to?
I believe the certification is on page 5. Let me see.
Page 5 is not a certification. You're looking at Exhibit 591A?
591. Yes, I can show it to you on my laptop if you'd like.
All right, that's the document that was in the separate binder pertaining to the direct examination of Plaintiff Adkins. At least I received a separate binder with that exhibit in it.
And that was also delivered to council this morning, I believe. So, Ms. Coltrane, now I'd like you to look at the next binder, actually, the smaller binder that was underneath the first, and to open to tab Plaintiff's Exhibit 591A. And have you had a chance to examine this exhibit before, prior to your testimony today?
Yes, I have.
And I represented to you that this was an excerpt of the certain pages of that full medical record. Is that correct?
That's correct.
And were you able to compare the pages from Exhibit 591A to Exhibit 591?
Yes, I was able to review every page.
Yes. What did your comparison entail? What did you do?
I went page by page, line by line, data point by data point, comparing the two, and deemed them both identical to each other.
Thank you. And I'll note that there were redactions, correct?
That is correct.
Redactions for personal identifying information
Yes.
in those records. Okay, and so then next I'll ask you to look at the next large binder that is next to you up there.
Okay.
And now you're looking at what is marked as Plaintiff's Exhibit 1. Did I provide you with a copy of this exhibit prior to your testimony today?
Not sure if I'm on the right.
Oh, this is, yes, Plaintiff's Exhibit 1. And so this is if you will look to, Plaintiff's Exhibit 10.
Okay. Yes.
So looking at pages 1 to 21 of this exhibit, did you review this exhibit prior to your testimony today?
Yes, I did.
And were you able to compare this to the previous exhibit, Plaintiff's Exhibit 591A, the excerpt of the certified transcript?
Yes, I did.
And would you describe what that comparison entailed?
Again, that is going through every page, every line, and comparing the two documents,
And what did you conclude in that comparison?
that they appear to be the same documents.
Thank you. Your Honor, I would move to admit Plaintiff's Exhibit 10.
All right, go ahead with whatever, I imagine you have
You want me
objections.
to deal with foundation first, or you want me to deal with everything all at the same time? Because I've got foundational objections, but then I'll also have other objections.
Let's start with foundational objections.
Okay. May I ask questions in aid of objection?
You may.
Ms. Coltrane, Exhibit 591, or I'm sorry, Exhibit 10, you did not produce those exhibits, is that correct?
We did produce these for the patient.
Okay, was that you personally?
Not me personally, it is my staff.
And did you provide these with the redactions on them?
No, we did not do the redactions.
And so you don't know what is underneath the redactions in Exhibit 10?
I know what was on the original, that is beneath the redacted portion. That is what I do know.
So you only
What
knew
was there in what we produced.
And said Exhibit 10 is the same as what you've just produced that was provided to us on Sunday, other than those redactions?
That is correct.
And did you compare the redactions in Exhibit 10 through the redactions in the other exhibits?
Yes.
And are the redactions identical between them, or do they have different redactions?
The redactions, to the best of my review, were identical.
Okay, so, Your Honor, from a foundation perspective, I'll have other objections, but I think with the redactions on these exhibits that they have not provided, I don't think there's sufficient foundation to show that, they should be admitted, because we don't have the actual original documents here. We don't know what's underneath the redactions. I don't really know what's behind those redactions, so I'd object on foundation. Then I have other objections as well.
I guess I'm a bit confused, because in looking at the plaintiff's Exhibit 10 and the binder I have, if those are the redactions we're talking about, I don't even see indicia of redactions.
They're at the very top of the page. If you see where it says, it says date of birth, redacted personal, MRN, redacted personal.
I see so I see that on the first page after the medical records transmittal page. Okay.
So if you look
All
at the
right, so I
header of
see,
each
all right,
page.
those recur throughout.
Right.
There's other redactions as well. If you look at page PX010.0014, there's redactions in the middle of that page. If you look at PX0100023, there's quite a few redactions on that page.
Or what was the second page you identified?
Is that 2-3? Page 4-3 has additional redactions on it.
What's the exhibit page number?
That's what it was. It was PX010.0043.
Oh, I see. So we're only looking at PX010 beginning at page 0001 and going through 0021. Those are the only pages that we would seek to admit.
See. All right, so there are some instances of redacted information on those pages.
And I would represent to the court, I see two instances, one on page 0018 and one prior to that, that Mr. Craig referred to on 0014, which both refer to a term vaginal delivery or, and then redacted. Both have the same language, and we have, from the start, redacted medical records and other information for relevance, and so have redacted information about other pregnancies as they are not relevant to this case and are private information for the plaintiffs.
All right. Well, it doesn't seem to me that the redactions pose a foundational problem with admitting these documents, pages 1 through 21 of Exhibit 10. So to the extent that's the objection, I'll overrule it. You can make other objections that you'd like to make, Mr. Craig.
Yes, Your Honor. Under, these are obviously medical records. It requires extensive medical training to be able to understand what these medical records are, what the terms mean, to be able to interpret the records. Plaintiffs have not called an expert witness to be able to interpret the records. They have not disclosed to us an expert witness to be able to interpret the records, and under Idaho law, the only expert that would be available or relevant is the treating physician as to whether an abortion is or is not allowed under Idaho law. So without the treating physician to be able to testify and give the treating physician's opinion as to interpretations and that treating physician's opinion, these records are not relevant to this case. Well, not only not relevant, but not helpful to the court because the court would not be able to understand it. And further, it's not relevant because they are not asking for relief related to any previous pregnancy or the abortions that they received. And so it's not relevant to that perspective, from that standpoint, because they're not asking for relief related to this.
All right, understood. Well, we heard during the course of the patient plaintiff's testimony, concerning their own medical circumstances. And as I understood the testimony, it's intended to bear on the notion that the way the statutes operate can deprive some women in some circumstances of the constitutional right of enjoying life, pursuing happiness, securing safety, in Article 1, Section 1 of the Idaho Constitution. And these documents would seem to essentially bear on that topic in the same way, to whatever extent that live testimony concerning those medical circumstances bears on it. They tend to, I guess, substantiate or corroborate in some fashion the testimony of the patient plaintiffs. Seems to me ultimately that while, as we discussed earlier, the individual patient plaintiffs' medical circumstances aren't the source of an entitlement to relief in the case, that nevertheless there is relevance. I'll overrule the objections. I'll admit Exhibit 10, pages 0001 through 0021. All right, you may continue.
What are you overruling Your Honor, are you overruling the objection related to the need for an expert witness to be able to interpret these? Because without the expert witness, these types of detailed medical records are not something that a layperson without medical training can understand.
All right. Well, I am overruling that objection, and the folks can argue the impact of these documents, whatever extent they have, but they are not expert testimony or a substitute for it. They are business records for which a foundation has been laid for admission. Go ahead.
Ms. Coltrane, I'd like you to now return to that first large binder and turn to what has been marked as Plaintiff's Exhibit 592. Did you respond to a request for records in this case for medical records for Jelaine St. Mitchell?
Yes, our facility responded to this request.
And what did you do in response to that request?
We gathered, we produced the records and provided them to the patient.
And do you recognize those documents that are in front of you as Plaintiff's Exhibit 592 as the documents that you gathered in response to that?
Yes, they are.
And looking again at what's marked as 592-0005, is that your certification of authenticity?
Yes, it is.
And what does that mean?
That means that, to the best of my knowledge, these are the records that were kept and produced during the period of care for this patient.
And now I want you to return to that smaller binder to look at Exhibit 592A.
Okay.
And were you able to review these records prior to your testimony today?
Yes, I was.
And did you compare those pages?
Yes, I did.
What did you do in that comparison?
I compared each page line by line, data points, and through the entire pages section,
What were you able to determine?
that they are the same pages.
And now finally, moving back to that third large binder, if you will look at what has been marked as Plaintiff's Exhibit 565. And we're looking specifically at pages 0005 to 0015.
Yes.
And were you able to review those pages before your testimony today?
Yes, I was.
And were these records that you produced in response to a prior records request or your staff?
Yes.
And when you compared these pages to the previous pages from Exhibit 592A, what were you able to determine?
I was able to determine that they are the same, the content is the same, with, of course, the notice about the redacted PHI.
I would move to admit Plaintiff's Exhibit 565, pages 0005 to 0015.
All right, Mr. Craig, go ahead. With any objections?
Apologize, what pages are you trying to admit again?
0005 to 0015.
So, Your Honor, in addition to the objections that we had from Ms. Atkins' records with Ms. St. Michelle's, on Sunday evening, they provided us approximately 82 new pages of documents, medical records that had not previously been produced. All of Ms. Atkins' records that they gave us on Sunday, from our initial review, looked like they had been previously provided. With St. Michelle, we had 82 pages of newly produced documents that they had not previously produced. So under Rule 37, there's a clear discovery violation. We'd asked for records. We had told them that we thought that there were records missing. And then on the eve of trial, we found out, yes, in fact, there were records missing. They gave us 82 new documents that they should have provided much earlier. So under Rule 37, C1, the court should not allow any of these records to come in as a sanction for them not providing us all their medical records. As a consequence of that, we've not been able to have an expert witness review the records or determine whether we need to have anybody else review the records.
11 pages at issue were or weren't produced before?
The 11 pages at issue, I believe were. So I've not, I mean, you can see I'm fumbling because they keep referring to stuff, and we've got 3 boxes full of binders and all that. So I think they were, but I can't say that 100% sure. But I don't think that matters, because the point is they failed to provide all the medical records. Without us having an opportunity to have an expert witness look at those medical records, they should not be allowed to use any of the medical records. They have willfully withheld records from us that they had an obligation to obtain. They did not give those to us, and they should not be allowed to use any medical records when they have violated a clear request for discovery.
All right. So I understand the production was incomplete. It would appear at this point that we're talking about a subset of the universe of medical records related to plaintiff St. Mitchell that was previously produced. These particular 11 pages were previously produced.
They were previously produced.
All right. Now, I guess I understand that Mr. Craig's argument that there could be circumstances in which producing a subset of records, of medical records, and failing to produce some other portion of the universe of medical records could be grounds for excluding any of the medical records at all. But in a circumstance here where the medical records at issue really are, I guess, just something that has some corroborative effect related to the medical testimony that the plaintiffs gave themselves, the patient plaintiffs, and are not themselves anywhere near a determinative issue in the case, as they might be in, say, a case that is a personal injury case where the injured plaintiff produces only some smattering of his medical records and withholds a large universe of them or fails to produce them, where there is clear potential for significant prejudice. This is just not that situation. So I'm going to overrule the objection. I'll admit these 11 pages of Exhibit 565 into evidence, pages .005, 0005, that is, through .0015. All right. Other questions for this witness?
I don't have anything additional for Ms. Coltrane.
Greg, if
Oh, Your Honor, thank you.
thank you for being here, Ms. Coltrane. You may step down.
Sorry. Thank you.
Plaintiffs may call their next witness.
Thank you. Next, I'd like to call the records custodian from St. Luke's, Caleb McInnes.
Good afternoon, Mr. McInnes.
Thank you, Mr.
Ms.
McInnes.
Kasich.
Mr. McInnes, would you state your name?
Caleb McGinnis,
Would you spell your last name?
McInnis.
And Mr. McInnes, what's your occupation?
I am a data integrity specialist at St. Luke's.
And what does that mean?
I am a custodian of records and release of information.
Did you respond to a records request in conjunction with this case?
Yes.
So I would like you, in that large binder, I believe the one that's nearest to you, though I'm not sure if they got reshuffled, to open to tab Plaintiff's Exhibit 596. Do you recognize these records as records that you gathered in response to a request in this case?
Objection leading.
What did you do in response to the records request that you received in this case?
I reviewed it and then processed the appropriate medical records.
Do you recognize those records in front of you as those records?
Yes.
And those are records for Rebecca Vincent Brown, correct?
Yes, that is correct.
I don't have a printed copy. Ma'am, could you pull up, let's see, exhibit. Oh, exhibit 595. You'll pull it up on the screen.
C-A-L-E-B.
Did you produce a certificate of authenticity in conjunction with these records?
Yes, I did.
And what does that certificate attest to?
That the medical records are true and original copies of St. Luke's records, and that I was the one that produced them.
And now I'd like you to look at the smaller binder next to you and to turn to Plaintiff's Exhibit 596A. Did you have an opportunity to review these records prior to your testimony today?
Yes, I did.
And were these records that were produced by you?
Yes, they were.
And so I'd like you to look specifically at pages 596-0131 through 596-0151.
Sorry, what were those pages again?
0131 through 0151. Were you able to compare the pages that I just named to the corresponding excerpt, Exhibit 596A?
I'm sorry, which pages am I supposed to be looking at?
So in this Exhibit 596, you are looking at 0131. Through 0151. Those are the, do you see where at the bottom in bold it says Plaintiff's Exhibit 596.0131 to 0151?
I see 001 through 0021.
Apologies are, we're looking at the records for Rebecca Vincent Brown, correct?
Yes, that's correct.
And you are looking at the binder with Exhibit 596?
596A, yes.
I believe he said 596A, and I don't know if that's the source, unless I misunderstood him. Could be the source of any confusion.
Yes, would you tell me again if those page numbers?
I see 0001 through 0021.
Were you able to review those pages before coming to court today?
Yes, I was.
And how did you conduct that comparison?
I looked at,
Apologies, I back up. Were you able to compare that to the document that you looked at previously?
Yes.
Exhibit 596.
yes, I was.
And how did you conduct that comparison?
I looked at the patient identifiers, the St. Luke's letterhead, the dates of service for the visits, and the headers for the different sections, and then a few lines in each section.
And what were you able to determine?
That the records were the same records and contained the same information.
And as you testified previously, you produced these records, correct?
Yes, that's correct.
Now, I'd like you to look at the next binder there, the next large binder to your right. And I'd like you to turn to Plaintiff's Exhibit 006. And now I direct your attention to pages 0037 to 0051. Were these records that you produced?
Yes, they were.
In what context did you produce these records?
I produced these records in response to a patient request I received last summer.
And were you able to compare these pages to the pages you just reviewed in Exhibit 596A?
Yes, I was.
And how did you conduct that comparison?
I looked at the visit dates, the patient identifiers, the St. Luke's letterhead, and then the sections and looked to see if they contain the same information.
And what were you able to conclude?
That they did contain the same information other than a few information that was requested by the patient that was different than the other request.
And what specifically was that information the patient had requested in these records that was not available in 596A?
Her immunizations and medication list.
But otherwise, the records appeared to be similar to you.
Yes.
Your Honor, I would move to admit Plaintiff's Exhibit 006, pages 037 through 0051.
Mr. Craig?
Your Honor, maybe I'm just confused, but I'm not seeing how these match up. If you look at, for example, she's starting at 0037, and then you go to 38. 0037 appears to be the same as the 0001 of 596A, but then you go to the next page and those don't appear to be the same. They appear to be substantially different. I'll have all my same objections, foundation. I think given these differences, I don't think they've laid sufficient foundation. In addition, with Ms. Vincent Brown, they provided, again, it looks like about 245, 248 pages on Sunday that they had not previously produced. And that's just what we could tell from a quick review, you know, not going page by page, but you know, that were the obvious newly produced documents.
If I could, Your Honor, since we aren't going to be able to admit the excerpts, which was the original idea, I would just have the witness compare the pages just identified in what was previously disclosed to the entire medical record instead of the excerpt, which I think might be the source of some of the confusion. So if we could look at, if that's...
Go ahead.
So could we go to that first big binder you had with Exhibit 596? And if if you would just look at pages 0131 to 0151. Do you recognize these as the pages that you reviewed previously?
Yes, I do.
And these were the pages that you had compared to Plaintiff's Exhibit 000 or 006.
Yes.
Your Honor, I would move to admit Plaintiff's Exhibit 006.0037 through 0051.
All right, so we have a new motion, I suppose. Mr. Craig, you're welcome to state your objections.
Again, Your Honor, I'm having a hard time matching these up. They don't appear to match up page by page, which was the problem my paralegal had when these were initially provided to us, one of those problems. So again, I'll object foundation. I don't think they've laid sufficient foundation to show that these were in fact the same records that were produced to us. In addition, the 595 that she referred to, the certification has a date November 7th, 2024, which is well after the discovery cutoff, the discovery deadline in this case. The 250 some odd or 240 some odd pages that they provided us that are newly produced at the last minute, clear discovery sanction, and you got to have an expert witness to be able to interpret these records. Otherwise, they're a layperson without that expert testimony can't understand these records. So I continue to object.
Understood. Ms. Kiesig, again, the pages at issue, Exhibit 6.
Exhibit 6, 0037 to 0051.
Those pages were produced in regular discovery rather than on Sunday.
Correct.
Will the objections on the rationales previously given and submit or admit those pages of Exhibit 6 into evidence?
Thank you. So now I would like you to look at Plaintiff's Exhibit 594 in that original big binder. Did you respond to a records request in this case for records for Kayla Smith?
Yes, I did.
And what did you do in response to that request?
I reviewed the request and then processed and pulled the requested information.
And did you provide a certification of authenticity?
Yes, I did.
And what does that certification of authenticity tell us?
That I was the one that produced the medical records and that they're true and original copies of the St. Luke's records.
And did you specifically review pages 0163 through, review page 0163, 0164, and 0165?
Yes, I did.
Did you also review pages 0267, 0268, and 0269?
Yes, I did.
Now I'd like you to look at that other large binder again at Plaintiffs Exhibit 001. Can you describe what these are?
They appear to be records from MyChart.
And what is MyChart?
It is an electronic service that patients can use to look at medical records from visits, schedule visits, and look at testing results.
Did you have a chance to compare the pages from the medical records you disclosed, specifically page 0163? We'll begin with 0163, 0164, and 0165.
Is that from the other binder?
Yes, sorry, yes.
Yes, I did.
What pages are we looking at?
So we were looking at 01 at from the first exhibit 565. Oh no, sorry, 594, 0163, 0164, and 0165.
What pages are those supposed to match up in Exhibit 1?
So that's what we're getting to. So if you, did you have a chance to compare those to the records produced from these MyChart records?
Yes, I did.
And looking first at page 163, did those correspond to records in the MyChart records, specifically looking at pages 001.0391 through 0392?
Sorry, what were those page numbers again?
They were in Plaintiff's Exhibit 001. We're looking at pages 0391 to 0392.
And could you repeat the question one more time?
Yes, did you have a chance to compare from Exhibit 594, page 163, 0163, to Plaintiff's Exhibit 001, pages 0391 to 0392?
Yes, I did.
And how did you do that comparison?
I looked at the section headers and then a few lines within the sections for the comparing information.
And what did you determine?
The information was similar but not identical.
And in what ways did it differ?
There were nursing notes from the MyChart records that were not in the other exhibit, and then a few notes in the other exhibit that aren't in the MyChart records.
What were the nature of the notes in the other exhibit, Exhibit 594, that were not in the MyChart records?
They were assessment and plan records.
So there were assessment and plan records contained in Exhibit 594, and in Exhibit 001 there were nursing notes.
Yes.
How significant were the nursing notes contained in Exhibit 1?
Objection. Lack of foundation for his knowledge as to know how significant nursing notes are.
How significant in quantity, if I may clarify?
They were about two lines.
And how significant in quantity were the the directions that were contained in Exhibit 594 on page 163.
I'm sorry.
The plan notes, I believe you said they were.
I'm sorry. Could you read the question again?
How large were the plan notes that were contained in Exhibit 594 on page 163 that weren't contained within those corresponding pages in the MyChart?
They were a few paragraphs.
Looking at page 164 of, Plaintiff's Exhibit 594-0164. Did you have an opportunity to compare that to Plaintiff's Exhibit 001.0392 to 0393?
Yes, I did.
And how did you conduct that comparison?
I looked at the section headers and a few sentences within each section.
And what did you determine about the comparison between those pages?
That they were the same through the time statement section of page 0164.
And then was there additional information in Plaintiff's Exhibit 001 on those identified pages? Or when you say that they were the same until which portion of the page?
The time statement.
Is that the time statement in Plaintiff's Exhibit 1 or Plaintiff's Exhibit 594?
594.
And then looking at, again, at Plaintiff's Exhibit 594-0165, did you have a chance to compare that to Plaintiff's Exhibit 001, pages 392 to 393?
Yes, I did.
And what did you conclude from that comparison?
To which page in 594?
To page 0165.
That the information was not the same.
And now moving to page, Plaintiff's Exhibit 594, page 267. From Plaintiff's Exhibit 594, that's page 267. And comparing that to Plaintiff's Exhibit 001, page 415. And did you have a chance to compare those?
Yes, I did.
And what did you determine through that comparison?
That the information was the same.
And now I'll ask you to look at Plaintiff's Exhibit 594, page 268. Compared to Plaintiff's Exhibit 001, pages 415 to 16. And were you able to compare those?
Yes, I was.
And what were you able to determine from that comparison?
That the information up through the plan of treatment on the MyChart record matched with the records from 594.
And then Plaintiff's Exhibit 594, page 296. And compared to Plaintiff's Exhibit 001, page 416. Were you able to compare those?
Can I be clarified the pages one more time?
Plaintiff's Exhibit 594, page 296, compared to Plaintiff's Exhibit 001, page 416.
And that information was not the same.
What was different on those pages?
Plaintiff Exhibit 594 contains an imaging result, while Plaintiff Exhibit 001 is plan of treatment and notes from an imaging result, but not the first page.
Oh, apologies. I directed you to 296. It should have said been Plaintiff's Exhibit 594, 269. And compared to Plaintiff's Exhibit 001, page 416. And were you able to compare those?
Yes, I was.
And what did you conclude?
The information is not the same.
And how is it different?
The Plaintiff Exhibit 594 is an assessment and plan note, while 001 is an imaging testing result.
Now, if you would look back to Plaintiff's Exhibit 001, 392. I believe it was page 392 where you determined that there was an assessment plan in the original on Plaintiff's Exhibit 594, page 164. If you want to turn back to 164 in Plaintiff's Exhibit 594. You'll see that there's an assessment and plan note at the bottom of page 164, correct?
Yes, that's correct.
And it's just that short to a paragraph assessment and plan that you had determined was not in the Exhibit 001, page 392.
Objection, pleading, and I'm so confused. I don't even know whether she's accurately stating stuff or not.
I'm going to call a halt to this at this point. This is not working. It's not going to work, and we have consumed far more time than the evidentiary value of this information at this point. So let's move on. It's just not working.
Your Honor, I would move to admit these exhibits on the argument that the information contained is the same and that the records custodian, to the extent that he's able to verify that at least pages of the original production of Exhibit 1, 391, 92, 93, 267, and 268 are all contained within what were certified records that he later produced.
Okay. Same objections as before. Any others?
Yes, he did not testify that they're the same. He testified that there's stuff that is in the new stuff that was just disclosed that was not in what they've previously provided to us. That's a clear discovery violation. And, again, this, Ms. Smith is probably emblematic of all their discovery violations. There's hundreds and hundreds and hundreds of pages of redacted information in these records that they did not provide to us. The records they provided to us Sunday night included at least 839 pages of newly produced medical records that they hadn't done it, that they hadn't provided. You need the full context of the medical records, not looking at things in isolation like they're trying to do. So, I mean, lack of foundation, discovery violations without the expert witness, all that.
All right, well, in this instance, I'm going to sustain the objections, not every single one of them, but it appears to me that this is an instance where we're really, we're talking about similar medical records, but not the same as those that were previously produced, and it's just created a whole new array of challenges in terms of trying to sort out what was produced and compare it to what was just barely produced before trial. It just was it was really not followable what the testimony was exactly. So I'm going to exclude those records. All right, now, again, I don't think it's a matter of grave consequence either way to how the case works out. All right, any more questions for
No
this
further
witness?
questions.
Any cross-examination?
Thank you.
Thank you for being here, Mr. McInnes. You may step down.
Thank you.
All right. We'll be in session, as I mentioned earlier, until about 4:30 today. So we'll take one more break. Perhaps now is as good a time as any.
Sure, yeah.
All right. Let's break until 3 o'clock. We'll be in recess.
All rise.
Please be seated. All right, plaintiffs may call their next witness.
Good afternoon, Your Honor. Cece Cocolette from the Center for Reproductive Rights on behalf of plaintiffs. Plaintiffs call Dr. Nicole Aker to the stand.
Good afternoon, Doctor.
Good afternoon.
Go ahead, Ms. Cocolette.
Cocolette, Your Honor.
Cocolette.
Americanized over time.
All right.
Good afternoon, Dr. Aker. Would you please state your name for the court reporter?
Nicole Aker.
Dr. Aker, what do you do for work?
I'm a family medicine physician.
Are you board certified?
I am
Where did you attend medical school?
at the College of Osteopathic Medicine of the Pacific Northwest in Lebanon, Oregon.
When did you graduate from medical school?
2018
Where did you attend residency?
at the Family Medicine Residency of Idaho here in Boise, now known as Full Circle Health.
Did you also complete fellowship training?
I did.
And where did you do that training?
The same location.
What did that fellowship training entail?
It was a high-risk obstetrics fellowship where I learned to manage high-risk OB patients and deliver surgically
Where do you currently practice medicine?
in Mountain Home, Idaho, and Boise.
What kind of hospital do you work in?
Primarily a rural critical access hospital.
What does it mean to be a critical access hospital?
I think it boils down to mostly having lack of resources when it comes to obstetric care. Most significant to that is lack of blood supply, lack of backup, and lack of resources.
What kind of care do you provide as a family physician?
Full spectrum family medicine, including all office-based procedures. I see infants, I see the elderly. I do inpatient pediatric medicine. I deliver babies both vaginally and surgically. And I do surgical procedures as well, including colonoscopies and other gynecologic procedures.
What kind of pregnancy complications do you see with your obstetrical patients?
Oh, all of them. I think the most common would be things like depression, anxiety, diabetes of all types, hypertensive disorders, multiples, on and on and on.
Do you provide care for miscarriages?
I do.
What does that care entail?
Objection relevance.
Your Honor, if I may, the witness testimony will show that the abortion bans are affecting more care than just abortion, including miscarriage management, so just trying to lay the foundation for that testimony.
All right, understood. Objections overruled. You may answer.
What does that care entail, Dr. Aker?
It entails a detailed conversation with my patient about the diagnosis and the management of that, including options, which would be medication management, surgical management, or watchful waiting.
Have you ever provided abortion care?
I have.
How does the care that you provide for miscarriage management compare to abortion care?
It is.
In relevance, we're going into expert testimony. She's not been disclosed as an expert.
Your Honor, Dr. Aker is not being offered as an expert in this case, but she is directly regulated by the bans as a family physician. So this goes to her own perception and experience under the bans.
Will you repeat what the question was, please?
The question was how the care that Dr. Aker provides for miscarriage management compares to abortion care.
All right, how the care she provides for miscarriage management compares to abortion care. All right, overruled. You can answer.
It is the same.
Dr. Aker, do you work with other specialists as part of your practice?
I do.
What does that look like?
All specialists. I'm neurology, urology, gastroenterology, surgery, including general surgery, maternal fetal medicine, and obstetrics.
Do you refer patients to maternal fetal medicine specialists yourself?
I do.
When you refer one of your patients to an MFM, do you remain part of their care team?
I do. There are two types of referrals that we make. One would be where they would take over care. I rarely have that happen. Most of the time, I maintain my patients and share care with maternal fetal medicine, or it's a consult question and they send the patient back with an answer.
And would you participate in that care from Mountain Home?
Yes, and also in Boise as well if I needed to.
Dr. Aker, are you a member of any professional organizations?
Yes.
What are some examples?
IFP, Ada County Medical Society, the Board of Family Medicine, and several others.
How long have you been a member of IAFP?
Since 2017.
Were you a practicing physician when you joined IAFP?
I was a medical student.
Dr. Aker, are you familiar with the laws at issue in this case?
I am.
What's your general understanding of those laws?
Objection, not an expert.
Overruled.
There are two laws, the total abortion ban and the 6-week ban. And my understanding is probably limited compared to many people's in the room, but that there are different standards related to those laws and different exceptions or confusing exceptions.
What's your understanding of the law's medical exceptions?
That there's an exception for preventing the death of the mother and exceptions for maintaining significant organ function. I can't remember the actual verbiage.
Do you find those exceptions clear?
No, I don't.
Why not?
They're not medical terms. I feel like, this is legal jargon that I wasn't trained to understand in medical school. It's not, there's no definition medically for what those mean. I mean, at what point do I have to be certain someone will die in order to intervene in their pregnancy? And pregnancy is a high-risk state anyway. Even up to 6 weeks postpartum, it's high risk. So at what point do I have to be certain? That's very difficult for me.
We'd object to on relevance grounds and not an expert. This is going into the substance of expert testimony which we've heard so far.
All right, well, it doesn't appear to be expert testimony to me at this point. I don't know, perhaps it will veer into that, but at this point, the doctor, as I understand it, is speaking to her own stated uncertainty about the impact of the laws, how they work. Overruled. You may continue.
Dr. Aker, how, if at all, have the abortion bans impacted the care that you provide to your patients?
Objection, relevance.
Overruled.
There's, I think the primary impact has been delay in care.
What's an example of a delay in care?
It can be as little as hours to as long as days. That's significant, especially in rural medicine, because like I mentioned before, we have lack of resources. And so timely diagnosis and treatment of any condition is very important, especially when a lot of patients that I treat live far away, like in Hawaii, it's hours away from Mountain Home. And so being able to get them treatment in a timely manner is important.
How could a delay impact a patient?
Well, for example, in this case, if we're talking about treating even, a miscarriage, if I sent the patient home and they began to bleed, they would take significant time for them to come back to the hospital. And then for us to get physicians to the hospital, because we don't have physicians that stay in the hospital all the time. And then hopefully have the resources, the blood products, et cetera, to treat the patient.
How have the laws impacted your practice, Dr. Aker?
It's certainly the delay in care has been difficult for my patients. It's also been difficult for me to navigate sort of what resources I have in order to help my patients, where I used to be able to rely on my medical judgment, and now I have to question if that's enough. And it certainly has led to professional strain and burnout.
Because of the abortion bans, have you been unable to provide care that you otherwise would have provided?
Yes.
Are there particular patients who come to mind?
Objection,
Yes.
Expert testimony.
Your Honor.
Overruled.
one particular patient was a patient that I'd been caring for since her initial prenatal appointment, planned pregnancy. She was excited about the pregnancy. She unfortunately came to the ER one day. She was pre-viable, and she had cramping and bleeding. The emergency room physician did an exam, noted protruding membranes, or the bag of water was coming through her cervix into her vagina. And they called the OB on call and explained, which was me because I was her OB, and explained what was happening.
What did it mean that she had bulging membranes?
In medical terms, one would call that an inevitable miscarriage or inevitable abortion.
What risks, if any, were there in delaying that patient's care?
I mean, all the risks that are already there, right? Infection, hemorrhage, and then the risk, of course, of her having a preterm delivery, whether that's in the ER, en route to the ER, those sorts of things. And then all of those are multiplied by being in a rural area.
What would you have done prior to the abortion bans?
Prior to the abortion bans, she would have been admitted to the hospital. She would have been offered options for treating her pregnancy, and that would have included termination of her pregnancy.
Were you able to do that in this situation?
No.
Why not?
Because there was a heartbeat still, and so in that case, it was recommended that she was not to be admitted to the hospital and to send her home because there was nothing we could do for her.
Why did you feel that you couldn't intervene at that time?
Well, I guess because of the bans. I mean, if there's a heartbeat, and even though it was certainly unclear, I knew the risks to the patient. I knew what could happen, but I'm still unclear as to what amount of certainty I would have to have that she could die or would die or that something terrible would happen. And going back to bodily function, like what does that mean in this case? Does she have to lose, her uterus? Is that a bodily function that's, protected by law? I don't know these things.
What ultimately happened to that patient?
She was discharged from the emergency department, and then she came back within the hour with her water having broken. And at that point, bedside ultrasound was performed, no heartbeat was detected, and she had surgical intervention to resolve her pregnancy.
How did that experience impact you?
I can't, it's difficult to put into words what that meant. As a family medicine physician, I feel like I have maybe more relationships with my patients than others. I knew her husband, that baby would have been my patient. It was really hard. It was hard to send her home and know that that's not what I would want done for me. I wouldn't have that for me. And to do that to somebody else feels awful.
Dr. Aker, have the abortion bans changed your practice for any other patients that come to mind?
Objection, expert testimony.
Overruled. You can answer.
Would you grant a continuing objection on that line of questioning?
That's fine. I don't have a problem with that. Go ahead.
Yes, another patient. This was a patient, again, that I had been taking care of, was already my patient, and she found out that she was pregnant. In her case, her HCG, or her pregnancy hormone, was detected, and it was rising, but there was nothing in her uterus.
What did it mean? So first of all, what is pregnancy hormone?
So the HCG is a blood test that we can do to either check to see if someone's pregnant, and then we also use that hormone level to monitor pregnancy early on when we don't have anything else to help us with that.
And what did it mean that the level was rising?
Well, in her case, it was not rising appropriately, and in the absence of anything in her uterus, it meant that her pregnancy was not viable.
When you say the absence of anything in the uterus, what could you see?
As I recall, I think just a gestational sac. There was nothing else.
There was no embryo or fetus?
No.
What would you have done prior to the abortion bans?
Objection calls for speculation.
Overruled. You can answer.
Prior to the abortion bans, I would have sat the patient down, told her what I saw, explained to her the risks, benefits, and alternatives of all of her options, including medication, surgical intervention, and watchful waiting.
What did you do in this case?
In this case, because of the laws and the confusion and fear around the laws, I had to call maternal fetal medicine, explain the case to them, ask them for guidance because I was unclear as to if this was something I could intervene on or if I had to send her to maternal fetal medicine in that case. And then I was given guidance by maternal fetal medicine to do some math regarding the percentage of the increase of the pregnancy hormone and then to put specific verbiage in my note to cover myself legally.
Did that delay the
And to the
patient's?
extent there was hearsay in that answer.
Your Honor, if I may, it's not offered for the truth of the matter. It's offered to show confusion.
Considered for that purpose only and not for the truth.
So did that delay that patient's care?
It did.
What were the impacts, if any, of potentially delaying that patient's care? Or said differently, what were the risks to that patient?
Risks to that patient, bleeding, significant bleeding, hemorrhage, of course, death in that case as well, infection, and then emotional, definitely emotional risks to that.
What made that situation difficult to handle?
I wish I could paint a picture of my day to you. And not only can I not offer my patient the guidance that I feel like I should be able to offer them, and there's a lot of, I think, reassurance from a doctor to their patient to be able to say, this is what's happening and these are options. I couldn't offer that to her in that case. But also, I had a handful plus more other patients waiting for me in my care. And so this delayed my ability to care for them. And I'm a person, I have children at home, and this delays my ability to get home to them. And it's not just a medical problem in this case. It's also a personal and professional problem.
Ultimately, what happened to that patient?
That patient ended up having a dilation curettage procedure to resolve her pregnancy.
And what was your role in providing that care?
I was the primary surgeon.
Dr. Aker, what have you done to try to understand the meaning of the bans and their medical exceptions?
Oh, I think everything short of going to law school. I'm just kidding. That's not. I feel like I have taken every opportunity to go to all of the groups and the meetings and try to be involved in the discussion. And I just can't do enough, I don't think.
Are there any resources that have helped you understand?
I think probably discussing with my colleagues has been the most helpful, especially with maternal fetal medicine and just seeing what my colleagues are doing here in Boise and what they understand. But also there have been listening sessions, like the IEFP put on a listening session with legal experts and physicians that I participated in. And Luke's has also offered a lot of St. Luke's, the hospital that I work for, has offered a lot of resources as well, including access to their legal experts.
Have those resources alleviated your confusion?
No.
Dr. Aker, there's been some suggestion that doctors are faking their confusion. What's your reaction to that?
Objection outside of personal knowledge calls for speculation.
Overruled. You can answer.
It feels offensive. I mean, I had to cancel a day and a half worth of patients to be here. That's 30 plus patients to be here. And to fake this, I have no words for that.
Dr. Aker, what kind of practice area is Mountain Home?
It's a rural area, about 17,000 patients with the base there.
What kinds of barriers do rural patients face to accessing care?
A good portion of that population lives under the poverty line. There's a lot of socioeconomic barriers, including transportation. We also have a lack of physicians in the area as well, or providers in that, for that matter, including specialists. And so there's a barrier for them getting even basic care.
How, if at all, have the abortion bans impacted rural patient care?
Objection outside of personal knowledge.
Your Honor, she's a rural provider. This is within her personal knowledge.
question as phrased was not to her knowledge, but broadly.
Happy to rephrase, Your Honor.
All right, go ahead and rephrase.
Dr. Aker, how have the abortion bans, if at all, impacted your experience as a rural provider?
Again, a large amount of my patients don't even live close, in the area. Owyhee doesn't have a hospital that does deliveries, and so those patients have to come in to Mountain Home for their care as well. And so it's delayed care.
Dr. Aker, as a provider, how has that impacted your practice?
I'm fortunate to be a family medicine doctor for a lot of reasons. Sorry. Ooh, did not mean to do that.
Fine to take your time.
One of the things I love most about my job is delivering babies and helping families grow. But I think about my own kids, and I think about the risk that I'm putting them in by continuing to do what I do, and I wonder if it's worth it. And as a family medicine doctor, I don't have to do OB. I don't have to do this work, but if I don't do it in places like Mountain Home, there's even fewer resources for patients, and who else is going to do it? And it's hard. It's hard to try to pick what's important. Is it my family? Is it my kids? Is it, or should I continue to do this?
Dr. Aker, no further questions, Your Honor.
All right, thank you, Ms. Coquillette. Mr. Grigsby, go ahead with any cross-examination.
We have 1 minute, or 1 moment, Your Honor.
That's fine.
No questions, Your Honor.
Okay, thank you, Mr. Grigsby. Thank you for being here, Dr. Aker. You may step down.
Thank you.
Plaintiffs may call their next witness.
Apologies, Your Honor. I have the next witness as well. Can I just have 1 moment to recombobulate?
That's fine.
Thank you, Your Honor. Apologies. Cece Coquillette, again from the Center for Reproductive Rights, on behalf of the plaintiffs. Plaintiffs call Dr. Lauren Colson.
Or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Good afternoon, Doctor. Go ahead, counsel.
Thank you, Your Honor. Afternoon, Dr. Colson. Would you please state your name for the court reporter?
Lauren Colson, Lorencolson.
Dr. Colson, what do you do for work?
I'm a family physician,
Where did you attend medical school?
I attended medical school at Western University of Health Sciences in Pomona, California.
Where did you attend residency?
At the time, it was Family Medicine Residency of Idaho here in Boise. It's now Full Circle Health.
How long have you been practicing?
Since 2015.
What kind of setting do you provide care in?
I provide care in a variety of settings. I am clinic-based for my own outpatient care, and then I do adult medicine in the hospital, and then I do OB care and some newborn care in the hospital as well.
What are some examples of obstetrical care that you provide?
Pretty much the whole gamut. So starting with prenatal care when someone first comes to clinic, seeking OB care, following them throughout their prenatal course in the outpatient setting, and then I do vaginal deliveries and postpartum care.
Do you also provide gynecological care?
Yes, I do.
Prior to the abortion bans, what role did abortion play in your practice?
Objection calls for speculation, not admitted as an expert.
Your Honor.
Overruled. You can answer.
So before the bans, as an extra job as a per diem physician, I provided abortion care at Planned Parenthood in Meridian.
Dr. Colson, do you supervise anyone in your practice?
Yes, I am the associate program director at a residency here, and I supervise residents and medical students.
What's your role within the residency program?
Associate program director, so I help the program director kind of overseeing scheduling and how we create the rotations and everything like that for the residents. And then, like I said, I have my own practice as well. Then I attend residents in clinic and in the hospital.
What does that supervision of residents entail?
Objection relevance.
Your Honor, the testimony is relevant to show the impact the abortion bans are having on physicians at all stages of practice, including in residency.
Overruled. Go ahead and answer.
I'm sorry, could you repeat the question?
Of course. What does that supervision of residents entail?
So the supervision of residents, depending on the training environment. So if it was in clinic, it might be me seeing that patient along with the resident, or it might just be them precepting that resident or telling us about the case and us kind of offering our advice and seeing if we need to intervene as well. In the hospital, it's a little bit more direct. We generally oversee the residents as they see patients in the hospital.
Have the abortion bans had an impact that you've observed on your residents' ability to provide medical care to pregnant patients?
Objection outside the scope of personal knowledge. Relevance not related to the plaintiff's as-applied claim in specific circumstances.
Welcome to respond if you like.
Thank you, Your Honor. Plaintiff's as-applied claim focuses particularly on patients with high-risk pregnancies. And as plaintiffs have made clear, that's not limited to just the plaintiffs in this case, but sort of the broader class of patients with high-risk pregnancies. And the resident's ability to provide care to those patients is directly relevant to those claims.
Again, the question was phrased broadly, not to his understanding.
Your Honor, I believe the question included that he's observed.
All right. Why don't you restate the question at this point?
Dr. Colson, have you observed an impact of the abortion bans on your residents' ability to provide care to pregnant patients?
Same
Yes, I have.
objections.
Answer stands. You can ask a new question.
I'm sorry,
Yes, I have.
what is that impact that you've observed?
I've observed a variety of things from, as I mentioned, I oversee residents in clinic, and a lot of what they do is obstetrical care in their practice and having to navigate different situations with them, with pregnant patients that have some sort of pregnancy complication and are kind of unsure of how they want to manage that complication. Our residents also in the inpatient setting work very closely with the maternal fetal medicine service and do a lot of the rounding and see a lot of the patients on the maternal fetal medicine service too. And we are kind of directly and intimately linked with that service. And I've heard a lot of distress from the residents taking care of those patients as to difficult situations and how to deal with them with the new abortion bans.
Objection, hearsay.
Your Honor, it's offered for state of mind, not for the truth of the matter.
I think they are trying to get to the truth of the matter asserted.
Well, I'm not sure. State of mind of whom?
Of the residents, Your Honor, of the declarant.
So what you're saying is what has been said to Dr. Colson by residents. You're offering essentially, as you said, with the past witness, evidence of confusion essentially, state of mind of care providers as opposed to the truth of any particular thing that they said.
That's exactly right, Your Honor.
That purpose. You may continue.
How have the impacts on residents affected you as their program director?
Associate program director.
Excuse me.
And it's our job to train the residents and to teach them and give them our medical expertise and what we would do in these situations where there might not be a clear answer, and especially as it comes into conflict with state laws. So our residents very often come to us seeking advice on how to proceed with patient care. And in a lot of those cases, that has to do with pregnancy care and their involvement in these cases where the care comes into direct conflict with the state laws.
Have you observed any impact on the residents wanting to continue practicing in Idaho?
Objection, relevance.
Happy to move on, Your Honor. Dr. Colson, are you a member of any professional organizations?
Yes, I am.
What are some examples of those?
At the state level, the Idaho Academy of Family Physicians, the Idaho Medical Association, the American College of Osteopathic Family Physicians, alphabet soup here, and of the Mountain West, and then nationally, the American Medical Association and the American Academy of Family Physicians.
How long have you been a member of IAFP?
Since I started in residency in 2015.
Do you hold any positions within IAFP?
Yes, I am on their board.
What are your responsibilities as a member of IAFP's board of directors?
We, as a board, meet quarterly, and our job within the IAFP broadly is to advocate for our members and provide them with things such as continuing medical education. We provide a conference. We listen to our members if they have any concerns and how we can advocate for them. That resulted in me being a part of the reproductive health subcommittee as well, because there was a lot of concern, especially in 2022 around these issues, so that we could help to educate our members and provide advocacy.
Objection, hearsay, related to the concern of members.
Overruled. You can continue.
How does the board identify IAFP members' needs?
Through a variety of avenues. They're welcome to email the organization directly. They can email our executive director, Liz Woodruff. They can reach out to any of the board members. We really try and have a board that represents a lot of the different regions of Idaho, and so they might reach out to a representative that's in their area, but they can talk to anybody. And then with our annual conference every year, it offers an opportunity for any of our members to kind of speak to anything that they want to and let the board know of any concerns or things that they would like us to look into.
How does the board decide what actions to take in response to member concerns?
I think it depends on the concern, and so sometimes it might be handled at the executive level with our executive director, the president-elect, former president, treasurer. If it's something that group feels like needs to go to the entire board, it can. If it's something that has to do with a specific issue, such as a reproductive health issue, it might go straight to the reproductive health subcommittee.
That's exactly where I was going next, Dr. Colson. So you mentioned the Reproductive Health Committee. What does that committee do?
Relevance.
Overruled. You can answer.
That committee was designed with members who specifically do a lot of work in reproductive health care and were specifically involved and interested in the changing laws. I believe it formed around 2022 when there was growing concern, and basically was designed to help provide guidance to our members as far as what our interpretations were of medical care that might be called into question under the laws, how to hopefully help doctors stay safe in both their patient care and not get into any legal trouble, and offer just a variety of resources for folks. We're not lawyers, so offering some resources to folks if they needed legal counsel as well.
So you've gotten into this briefly, but what sort of actions did the Reproductive Health Committee take in addressing those member concerns about the abortion bans?
Gosh, there was a lot. I think early on we were creating documents, trying to send things to our members to educate them on different issues. We provided continuing medical education opportunities. We had some legal groups kind of give their legal interpretations of the laws through like webinars and things like that. We, at one of our conferences, gave a talk as far as what I understand of what we were calling the post-Roe landscape was as it pertains to Idaho and how physicians can practice. And we provided advocacy. We worked very closely with Idaho Medical Association as well. We at the time especially didn't have a direct kind of lobbying arm, and so we spoke a lot and communicated a lot with the Idaho Medical Association, who does a lot of our lobbying.
Did the Reproductive Health Committee ever get in touch with anyone in government about the abortion bans?
Yes, we did. I believe early on we went to the governor's office, and we weren't able to meet with the governor, but we met with some staffers and kind of spoke to some concerns and spoke to some specific examples of medical cases within pregnancy that might come into conflict with the law. We also tried to meet with some legislators who were willing to meet with us as well.
What were the outcomes of those meetings?
I remember a particular meeting with the governor's office and them listening and hanging on to pretty much every word we were saying as far as all the complications that could arise and why family physicians were having a really difficult time with this and practicing OB, and them understanding the gravity, but then basically admitting that it was over their heads and saying that, you know, we were going to have to figure out how to practice medical care, and then that was our job to do. And you know, if we had an issue with
speculation and hearsay.
Your Honor, if I may. Go ahead. Again, this testimony is not offered for the truth of the matter, but for the effect on the listener, and in particular, how it motivated IAFP's subsequent conduct in trying to understand these laws and provide guidance to their members.
All right. Well, I don't think it calls for speculation. I'll overrule that objection, and I'll limit my consideration of the hearsay aspects of the statements to the purposes you noted. You may continue your answer if you recall where you were. If you need Ms. Coquelet to ask a new question to refocus things, that's fine too.
Okay, thank you. Yes, so essentially we were told that, or I was told that we as a medical community and as the IFP needed to kind of figure out how to navigate these laws and learn how to practice medicine under these laws, even though we had told them directly that we were, you know, confused and didn't know what to do in these different scenarios. And basically we were advised that we needed to take it up with the legislature if we needed the laws changed.
So were the state officials able to offer you any guidance?
No, they were not.
Without guidance from the state, how have you been navigating these laws in your practice?
Objection, relevance.
Overruled.
We've been trying our best. I think most of us in how we provide medical care, especially as it has to do with pregnancy care, it's hard to wrap our heads around this being something that could be considered criminal, but we don't want to find ourselves in a situation where we could end up going to jail. And so I know that how I have changed my practice and how I have advised some of my colleagues in clinic is basically just to stay away from anything that could be considered or construed as in violation of this law and could land someone, you know, in court or in jail. So it's had vast impacts on how we practice pregnancy care.
Dr. Colson, I want to focus in on your understanding of the laws at issue in this case. Are you familiar with the laws at issue?
Yes.
How did you become familiar with them?
Well, I think we all had to become more familiar with them than we ever anticipated after the Dobbs decision came out, because we had to figure out how we were going to practice medicine and not get ourselves into trouble. So, you know, that was reading the law directly word for word and trying to understand it, trying to talk to legal folks and what their understanding of that was, trying to talk to colleagues and seeing what other people were doing.
What's your understanding of the challenge laws?
Yeah, my understanding is that there are multiple laws on the books that are similar but not exactly the same as one another, and that essentially the one that for the most part supersedes the others is what we refer to as the total abortion ban, or 18622, which basically says that, you know, all abortions are to be considered criminal except in certain circumstances which are laid out in the law.
What's your understanding of those exceptions?
My understanding of those exceptions is there's one for ectopic pregnancy, molar pregnancy, removal of the dead fetus or something like that. I don't quite remember the wording on that. In the cases of rape or incest, but there has to be a police report within 7 days, and it has to happen within the first trimester of the pregnancy. Oh, and to prevent the death of the mother.
Do you find the medical exceptions clear?
No.
Why not?
I think they started to list out a couple conditions that were mentioned. I think in the previous case with Planned Parenthood, with ectopic and molar, but there are just so many more circumstances beyond those that can complicate a pregnancy. And so the kind of coverall for the rest of them is just this: prevent the death of the mother. And my understanding is after the Planned Parenthood case that it said that there doesn't have to be any imminency to that, but still, when someone gets sick in pregnancy, it's really hard to tell when and if they're going to die from a medical condition. And that's just not the way we operate. When we have someone with a pregnancy complication and we have medical treatments available to us, those are what we go to. And if we're barred from using some of those treatments and what would be the standard of care in a lot of circumstances, because we have to be preventing the death of the pregnant person, that remains unclear.
Dr. Colson, I want to shift gears a little bit and talk about IAFP's role in helping doctors navigate the bans. Has IAFP taken action to try to alleviate its members' confusion?
It's tried its best. Like I said, through the Reproductive Health Subcommittee, we created on the IAFP website just a bunch of resources for folks. Anything that was provided, such as, like I mentioned, webinars on legal interpretations, CME, best practices, things like that. All of those were put up on the website for our members. Like I said, there are a variety of forums, webinars, conferences where we talk to our members. We tried our best to reach out to our members and provide what clarification we could.
I want to talk about one such example, and I'll pass you up the exhibit in just a moment.
Yes. Do I need both of those? Yeah, thank you.
Okay, Dr. Colson, I've just handed you what's been marked as Plaintiffs Exhibit 491 for identification. Do you recognize this?
Sorry. Yes, I do.
What is it?
This was a presentation that I gave on emergency contraception through the IFP.
How do you recognize it?
I prepared this presentation for that presentation.
Does it appear to be in the same or substantially the same condition as when you prepared it?
Yes, I believe it does.
Your Honor, I offer Plaintiff Exhibit 491 into evidence.
We would object, and we would object on the basis of hearsay.
All right, well, it undoubtedly would seem to be that.
That's right, Your Honor. And again, I'm hoping to use this exhibit to show confusion, not for the truth of any matter asserted in there.
The truth of the matter asserted is central to what the document is.
I understand what you're saying. The truth of the matter is the document is full of factual information, in other words. And you're offering the document to try to show the fact that it exists evidences the need for the information?
That's right, Your Honor.
Is that it?
Mm-hmm.
All right. Well, I suppose that the document may have some value for that purpose. So I'll admit Exhibit 491. I won't consider anything in it for the truth of the matter asserted. It's just to indicate, I suppose, a perceived need among the relevant universe of medical providers for information like this in the wake of the Dobbs decision. All right, you may continue.
Dr. Colson, what was Plaintiff's Exhibit 491 prepared for?
I think there was a lot of confusion around whether physicians and through the IEP, family physicians could provide emergency contraception post Dobbs, and so we decided to provide a continuing medical education virtual presentation webinar on emergency contraception.
Dr. Colson, I want to direct your attention to page 3 of this document, which is stamped ADK 1931 on the bottom right-hand corner. Could you read that portion out loud?
Yes, the title slide says quick legal update.
And why were you giving a legal update in a continuing medical education program on emergency contraception?
Yeah, as I mentioned before, there was a lot of question and concern as to whether emergency contraception would fall under something that could be construed as illegal under the total abortion ban, and so because of that, with anything reproductive health care that we were providing, it was helpful to give our audience an update on what our understanding was of the laws and where the laws were at the time we were giving the presentation.
And I apologize, Your Honor. I neglected to publish the exhibit.
All right. Well, I have a copy here. And I'm not sure our projector equipment is working at the moment in any event.
Okay.
All the publishing there will be.
Your Honor. Dr. Colson, I want to direct your attention to page 7 of this document, which is stamped ADK 1935. Could you please read this portion out loud?
Yes, there's a title that says in quotes, necessary to prevent death. Underneath that, it has bullets that say what is covered by this, and then with question marks, preeclampsia / HELP syndrome, or HELP, preterm premature rupture of membranes, ectopic pregnancy, incomplete miscarriage, molar pregnancy, abruption, placenta previa.
Why did you give that list of conditions?
Because we were given this law that said we could do what was necessary to prevent the death of the mother, and that we weren't sure what pregnancy conditions would be covered on this. And then I gave just a list of some examples of things we were unsure of.
And what about necessary to prevent death makes it unclear whether these conditions are covered by the laws?
A lot of the conditions here listed are things that might happen in different points within the pregnancy and are progressive. And so while all of them might lead to a very severe condition in which the pregnant person may die, and that it might seem like you could intervene under the law, they might not present that way when they are first diagnosed. And so the question was, again, when you could provide an abortion within the spectrum of each illness.
Dr. Colson, in your observation, have the actions that IAFP has taken alleviated members' concerns about the abortion bans?
I'd like to think so, but I think...
Your Honor, Dr. Colson's testified that as part of his responsibilities on the board and on the Reproductive Health Committee, hearing these concerns is part of his job.
Overruled. You may continue your answer.
I'd like to think so, but to my understanding, our members are still quite concerned with regards to the laws.
What's your understanding of why?
Yeah, my understanding is that while we've tried to provide as much guidance as we could, like I just mentioned in this slide, we're still unsure. And I think a lot of this remains to be tested as far as, if folks end up getting prosecuted under these things, and no one wants to be that test subject. And so we just don't know.
Why does nobody want to be that test subject?
Objection calls for speculation.
Happy to rephrase, Your Honor.
Go ahead and rephrase.
Why would you not want to be that test subject?
If I were to have to go through all this, not only could it, again, land me in jail, but even just the time to prepare for court, to be in court, would result in lost time in my clinic. I could lose my job, I could lose my practice. My patients would suffer because I wouldn't be able to take care of them. It's a lot of lost time, even if the decision was ruled in my favor, and if it wasn't, then I'd go to jail, which I certainly don't want to do.
Dr. Colson, you mentioned the Idaho Supreme Court's decision in the Planned Parenthood case. You're familiar with that decision?
Yes.
Are you aware that the Idaho Supreme Court said in that case that there's no immediacy requirement and no certainty requirement in the ban's medical exceptions?
I am aware that they've said that.
You can continue.
Did that decision alleviate your confusion?
No.
Why not?
As I was mentioning in the circumstances before, a lot of these medical conditions are developing in their severity, and we don't know what the outcome is going to be. And so, while there doesn't have to be an immediacy or certainty component, it's still there's question, when I can intervene. If someone gets diagnosed with preeclampsia and had severe preeclampsia in a previous pregnancy that they almost died from, and we know it's going to be worse this pregnancy, but they're, I don't know, in their first trimester and they are showing no signs of preeclampsia yet, or very few signs, am I allowed to intervene then? Do I have to wait until they develop those severe signs? Do they, have to be at a point when I feel like termination is the only option for them? I think that there's still a lot of uncertainty there.
Dr. Colson, have the abortion bans impacted your practice as a family physician?
Yes, it has.
How have they done that?
I think that there have been a variety of situations with pregnant folks that I have run across, or folks that have unfortunately lost their pregnancy, where there's a lot of question and uncertainty that enters my mind as far as what I'm allowed to do for the management of that patient.
Are there particular patients who stand out in your mind?
Yes, there's. Oh.
Sorry, what was the
Objection leading. And relevance.
Other patients that stand out in your mind, I would say that's not leading, and I'll overrule the relevance objection. You may answer.
Yes, there are a couple that I mentioned in the complaint that come to mind.
Before we get to those patient stories, in your experience, does delaying care impose risks on a patient?
Yeah, absolutely.
What kind of risks?
Depending on the circumstance, in the case of pregnancy, if they, again, were having some sort of medical condition that, if left untreated, could progress and become more serious, there could be significant bodily injury, infertility, or even death. In other cases, there could be infection, bleeding, variety of things.
In your experience, could those risks arise in the time that it takes for a care team to determine whether that care is permissible under the abortion bans?
There certainly could be, depending on when the person is presenting to care. There could definitely be an urgency component to it.
So Dr. Colson, let's turn now to the patient stories that you referenced. With respect to the first patient, what had happened when you first encountered that patient?
Objection relevance. These individuals are not before the court or related to patients' claims.
Understood, and I'm going to overrule the objection, and I'm going to indicate my understanding of the perceived relevance, and that is that, again, the claim in Claim 3 in the case is that Idahoans have a constitutional right, among other things, to enjoy and defend life, pursue happiness, and secure safety, and that the information to which Dr. Colson is going to testify is intended as an example of the ways in which the statutes allegedly interfere with that right. Of course, it remains to be seen whether that sort of thing does ultimately prove interference with a constitutional right, but it's offered as evidence of that. I'll hear that evidence.
Dr. Colson, what had happened when you first encountered that patient?
The first patient, I believe that I listened to the complaint, was the one with an IUD in place who had a positive pregnancy test, had gone to see their primary care provider, and they wanted the IUD removed, and we're unsure, but we're thinking that they wanted to continue that pregnancy. That provider felt like they were unsure if they could do that, and there was concern around the abortion bans if that was to end the pregnancy, if that would be considered criminal. And so that patient originally was referred to an OB who unfortunately couldn't see them due to insurance reasons, and so they were then referred to me to care for them.
How would you have handled that patient's care prior to the abortion bans?
I think that patient wouldn't have even come to me. I think that the other provider in the community definitely had the technical skills to remove an IUD, but because of their concern with the laws, they came to me to perform that procedure.
And you mentioned being concerned. Why were you worried that providing that care could potentially be perceived as providing an abortion?
Yeah.
Leading.
All right. Well, I'm not sure if he had directly said that before. So I'll have you rephrase.
What made you concerned about providing care to that patient?
Objection.
Overruled.
Yeah, well, the patient was pregnant and had an IUD, had an IUD in place, and removing the IUD could end that pregnancy. The risks of removing an IUD would be spontaneous abortion of the pregnancy and infection. Leaving it in could cause spontaneous abortion and an infection. But the fact is, if it was left in, I wouldn't have done anything. Whereas if I removed the IUD, I would have done something to end that pregnancy. That patient ultimately wanted to continue that pregnancy when I met with them. But they were uncertain at the time that they were initially referred to me. And so my concern was the intent of it, or as it could be perceived as if I had removed the IUD and the pregnancy had ended in this, and that was what that patient was hoping would happen, whether it would have happened or not. It could be, the intent could be perceived as if it was done for the intent of providing an abortion. I was very worried about this patient coming to me after seeking care with 2 other providers and not being able to offer them the care that they wanted. I talked to several colleagues. I talked to as many folks as I could to see what their interpretation as far as if I was going to run afoul of the law. When they came to me, as I mentioned, they notified me that they wanted to continue the pregnancy. That helped alleviate some of my concerns in providing the procedure. And then I just, documented as best I could that it was not done for the intent of terminating the pregnancy, but based on the risks, weighing the risks of leaving the IUD in versus removing it.
How did that experience affect you?
This was something that should have been very simple, something I probably wouldn't have thought twice of before. It would have generally been looking again at the risks, standard of care to remove the IUD in the pregnancy, regardless of if that person wanted to continue that pregnancy or not. And I would have just removed the IUD. It's a very easy procedure. It would have taken a small amount of time in my clinic and a very small amount of my time in standard documentation. Because of this, as I've been saying, I racked my head over this for a couple days until I saw the patient, and then had to spend a lot of extra time documenting it as well to make sure that I felt like that this couldn't be called into question.
Have the abortion bans impacted the care you've provided for any other patients?
Yes, it has.
What happened when you first encountered that patient?
So at my clinic, I'm one of the few providers that can provide uterine aspiration for miscarriage care. And so I get patients referred to me by my colleagues in order to provide miscarriage management. I recall a patient who was seen in the emergency department first. They knew they were pregnant. They went into the emergency department with, I believe they had some bleeding and cramping. And in the emergency department, they had an ultrasound done, which showed a non-viable pregnancy and fetal demise. And so they were not offered miscarriage management in the emergency department, but told to follow up with their obstetrical provider. They were a patient of ours at our clinic. They went and saw one of my colleagues who looked at the report, but felt like they had to repeat the ultrasound themselves in order to perform or recommend miscarriage management. And so they performed a second transvaginal ultrasound in clinic and documented their findings. They did not feel like they had the clinical expertise to perform the miscarriage. That person had opted for a uterine aspiration, and so they referred them then to me.
Objection outside of the witness's personal knowledge.
Your Honor,
What part of it outside the witness's personal knowledge?
Through the testimony, he's talking about what the other doctor did and understood and all those kind of things that would have been outside of his personal knowledge.
All right, well, I suppose you can ask a question to clarify how Dr. Colson knows what he testified to concerning the other doctor, the referring doctor.
How did you become aware of that patient's circumstances prior to the time they were referred to you?
Yes, through reading the EMR, so through the medical records of that ED visit that occurred, as well as my colleagues' records of that. And then, of course, because they were referring to me and we work closely with each other, then they personally notified me as well of this case that they had referred to me.
Objection, hearsay.
Overruled, and it appears to me that the information is being offered for its intent, or for its effect rather, on Dr. Colson. Is that fair?
That's exactly right, Your Honor.
All right, I'll consider it for that purpose. Go ahead.
Dr. Colson, what did you do then once that patient came to you?
Yeah, so once that patient came to me, they came to me specifically just to have the uterine aspiration procedure because they had, as I had mentioned, already been diagnosed twice with a fetal demise. I unfortunately had to tell the patient that I had read the reports but didn't feel comfortable being the one providing the uterine aspiration until I had personally confirmed that they had indeed had a fetal demise. And so I notified the patient that in order to perform that and feel comfortable doing that under the laws, that I would have to repeat a then third transvaginal ultrasound on this patient in order to confirm the demise and perform the procedure in clinic that day.
And why did you feel that you had to repeat that ultrasound?
Because I was the going to be the provider of record that performed the procedure, and if someone was saying that this was an abortion, then I would be the one that could go to jail for it.
How did that experience impact you?
Yeah, it definitely made me feel real bad for the patient that they had to go through a third ultrasound in order to provide care for their miscarriage, which normally I would have just trusted my colleagues and their ability to perform an ultrasound in order to diagnose the failed pregnancy. And then after that, performing the procedure, I remained nervous that even though I knew that this was a miscarriage, because the procedure for an abortion versus a uterine aspiration for miscarriage is indistinguishable, that someone could call this an abortion. And then because of those thoughts, again, over-documented, even cited, the New England Journal of Medicine's 2013 definition of early pregnancy loss in order to have evidence that I had done my due diligence of diagnosing a pregnancy loss before performing the aspiration.
What are the impacts on your practice of feeling like you have to do all this documentation?
It's really stressful. It definitely leads to lost time because we have to document these cases more thoroughly, and it definitely makes me think twice. Every time I get one of these cases referred to me, that I have to cross my T's, dot my I's, make sure that that I am proving for certain, even though I know that this is a miscarriage, that someone else that might be reviewing this could easily, see through imaging and through documentation that it was a miscarriage before providing the care.
Dr. Colson, have the bans also impacted your personal life?
Yes.
Your Honor, if I may, the testimony is relevant to show the impact the abortion bans are having, not just on providers as physicians, but also personally as residents of Idaho.
Sound, I guess, unsympathetic, but that does not sound like a relevant issue in the case. So I'm going to sustain that objection.
Dr. Colson, what have you observed about how physicians who provide care for high-risk pregnancies have changed their practice in response to the bans?
Objection calls for speculation, lack of personal knowledge, discussing what other doctors are doing, rather.
Your Honor, I'm just asking for the witness's own perception.
State the question again, please.
What have you observed about how physicians who provide care for high-risk pregnancies have changed their practice in response to the bans?
All right. asking for his observations. I suppose if you have any, you can answer.
I mentioned earlier our family medicine OB team works very closely with the maternal fetal medicine doctors in the hospital and help them run their service, and our residents help them with these complicated patients. I have personally seen the distress that it's caused my maternal fetal medicine colleagues and been involved with these cases where there is question among staff, amongst other doctors that has interfered with the care of folks due to concerns that we might be in violation of the abortion bans for providing care. And so I've seen maternal fetal medicine doctors that are more than capable of handling the patient that's in front of them feel like others choose to leave the state directly because of the abortion bans.
Dr. Colson, have you considered leaving Idaho because of the abortion bans?
Objection, relevance. I think we've gone to physicians.
That is an issue that I think goes to a broader market impact, not to the rights of women with high-risk pregnancies to obtain care at issue. So I'm going to sustain that objection.
That's it, Your Honor. I'll pass the witness.
All right. Thank you. Cross-examination, Mr. Grigsby.
Your Honor, we are at 4:10. I don't anticipate the testimony will be extremely lengthy. I wanted to see when you thought we might want to break today.
Well, if I have another matter scheduled at 4:30, and so somewhere around then, I'm hoping we can get Dr. Colson finished if possible. By saying that, I'm not trying to limit the amount of time you can take, but I'd like you to get rolling and see whether you get finished or not.
I understand. Thank you, Your Honor.
All right.
Good afternoon, Dr. Colson.
Good afternoon.
You previously completed a deposition as Idaho Academy of Family Physicians representative,
Yes, I did.
and you were at that time designated to speak on behalf of IFP at the deposition.
Yes, I was.
IFP does not practice medicine as an organization, correct?
It does not.
IFP does not employ any medical professionals who practice medicine as part of their duties for IFP.
To my knowledge, it does not.
IFP does not operate any medical facilities.
To my knowledge, it does not.
Idaho's Defense of Life Act and Fetal Heartbeat Protection Act have not harmed IFP, correct?
That is not correct. It's harmed IFP through harming its members.
You recall completing a deposition in this case?
Sorry, I didn't understand. Can you repeat?
Yes, I certainly can. You recall completing a deposition in this case?
Yes, I completed a deposition.
And you were under oath?
Yes, I was.
Okay. I believe that the white binder, 1 of 3, is up there. And could you turn to, it's tab 17. It's a white binder. I believe it's under the black binder.
Okay. Where am I turning?
So it's exhibit number 1017. It's tabbed as exhibit 17. And it's within that exhibit, it's page 24. Page 56 rather.
Sorry, it's a little confusing. Is it page 54, like that little small part on there?
Yeah, it's divided up, but the bottom of the page will indicate the 56.
Page 54.
Yeah, 56, and then it starts in line 10.
Okay, yes, got it.
Could you read from line 10 to line 21?
Yes. How have Idaho's abortion laws harmed IAFP as an organization? As an organization, it's harmed the IAFP by harming its members and how they provide medical care. So no harm directly. Objection, calling for legal conclusion. So I guess there's been no legal, the abortions have not, sorry, I don't know how to put this. It harms its members, which then in turn harms the IFP is the best I can answer that question.
Objection, Your Honor, improper impeachment.
It's, the answer in the deposition seems to be consistent with the answer given today. Is that what you mean by that objection?
That's exactly right, Your Honor.
I would say it really doesn't have impeaching effect at this point, but I'm not sure what to say. Do you want me to strike the deposition testimony that was just read, which wouldn't seem to make any difference whether I do that?
I would ask that it be stricken, Your Honor.
Your Honor, it is not directly what he said, and it provides a more full answer that explains his position.
Well, what I'm going to do is I will consider it. I don't think it was impeaching. It didn't strike me as impeaching, but it's the as I understand it, Rule 30b-6 deposition testimony of a party to the case, which an opposing party can use, and I'll consider it as additional testimony on that theory. Go ahead.
And Judge, we would move to admit these excerpts of Defendant's Exhibit 1017.
All right, the ones that were just read into the record, and those were, just for clarity, the page and line numbers again.
Page 56, line 10 to 21.
All right, those will be considered part of the evidentiary record for decision in the case.
Nothing further.
Okay, thank you. Any redirect?
No redirect, Your Honor. Thank you.
All right, thank you for being here, Dr. Colson. You may step down. We are now at 4:15. As I mentioned, I have another matter that starts at 4:30. If you think you can get something done in the next 10, 15 minutes, I'm not adverse to that, but
I fear we can't. I think we made up some ground after the medical records, Your Honor, so I feel like we're on a good schedule right now, and it'd be appropriate to break if that's acceptable to the court.
all right, it's fine with me. I mean, I'm not. I know some folks' personality, judicial personality, involves we're going to use every minute, or somebody's in trouble. That's not mine. So we'll recess for the day. We'll reconvene 9 o'clock tomorrow morning. We'll see you then.
All right.